Uh, Good morning, everyone, and compliments of the new year to all of you, to the media, any member of the public who's here, our team of transcribers, all of you over there, the evidence leading team, the NPA team, Advocate Chauke's legal team, our staff, compliments of the new year. Advocate Chauke, Advocate Batoi, we have met you. I can safely say you have received our hugs this morning, both of you. Good morning again. Thank you very much for your presence today, and hopefully all of you have had a very good beginning of the year. We wish you the very best. Ntate Motlamoyane, we're going to give you an opportunity to tell us what you want to tell us from where we ended last year. Then we can take the matter from there. Thank you.
Thank you, Madam.
Perhaps before that, may we again just place ourselves on record. I know that we have new faces here. Are we all new? I mean, the media. Those of you whom we have not met, later when we adjourn, we will know one another. I'm sure from, oh, I beg your pardon, sir. I think there's someone here from the media. Please be part of this family. Introduce yourself if you wish.
Morning. My name is Moloto. I'm a reporter with the
Ntate Moloto, good morning. You're welcome. I see members of the media, the faces are quite familiar, all of you. Anyone who's new in this family can raise up your hands. Ndade? We didn't hear. What's your name?
Mlindi.
Ndade Mlindi.
The name is Mlindi Kasa. I'm doing live streaming. Kasa, yes.
Good morning, Mr. Gasa. Are you from the media? Which house?
No, I'm a service provider.
You
Not with the
service in-
media house, yes, ma'am.
Yes, thank you. Anyone else? You're most welcome. Any new face on my right, the media? Do I all know you? You've been with us since last year. Okay, family. Anybody else who is new here?
Hello, my name is Fihliwa Minga. I'm part of the media, ENCA.
NCA. Miss Linda, you're welcome, Danam. Anyone else on the left side who is new? Advocate Koitobi, I know you have a new member.
Yes, Madam Chair. In fact, I suppose I have two new members because Mr. Tembelihle Links has now been formally briefed by the State Attorney. He has been part of us since we started, but not as counsel, as I suppose Mr. Ramokhada's appendage. But he's now been promoted. The second person is Ms. Michaela Kritzinger, who's also been briefed to support us. So we would like to formally introduce them.
She is also an advocate.
Yes, she's counsel as well.
She's counsel as well. Most welcome, you both counsel. I congratulated you last year. Ms. Advocate Christensen, most welcome. You are now part of this family. Any other new member? Most welcome. You know all of us here in front of you. and we hope we're going to have a pleasant next few couple of months if the President gives this inquiry an extension. Ordinarily, we're supposed to end at the end of January, but we are still at the beginning of the inquiry. We hope that we will receive the response from the President in due course. But for now, until the end of January, I suppose we are going to continue. NPA team, you're most welcome, Madam. Our spokesperson, you're part of the family. Advocate, I beg your pardon, Ndadam Kabela.
If Mr. Nkaitobi allows me to speak, because when he's around, I don't speak. But I do have a student, Joshua Norton, who is with me doing a vacation job with me for 2 weeks. And he's joined us for the week. Thank you.
Thank you very much. I'm sure Council allows that. Mr. Norton, you're welcome. Are you serving articles?
Not yet. I'm still a law student at Wits, so I'm just shadowing Ms. Nkabinde for the next 2 weeks.
Second year, third year, final year students?
Going into my 3rd year.
Your 3rd year. You are most welcome, and the very best to you as you pursue your legal studies. You'll probably be sitting in front of us next time in court. So we wish you the very best. Thank you. Advocate Mtlamuyane.
Thank you, Madam Chair, and your co-sisters. When the matter was adjourned on the 15th of December, 2025, Advocate Patohi had interrupted her evidence because she was seeking legal advice. Now, it is important that we should place it on record, the position as it pertains today. On the 23rd of January 2026, which was last week on Friday, the evidence leaders received a letter from Advocate Patohi, who was informing us that the position as it pertained on the 15th of December 2025 is still the same. She has not yet received legal counsel which she sought. She informs us that she asked for a senior counsel and a junior from the Office of the State Attorney last year. And the Solicitor General, the acting Solicitor General, did not provide one, but advised her to approach the minister in that regard. On or about the 8th of January this year, the minister responded and suggested that because the NPA has a legal team in the form of Advocate Hali SC and her junior Advocate Lekgeto, that she should utilize their services. Now, she further states in her letter that she then expected that Advocate Hali SC and her junior would advise her. And Advocate Hali SC wrote a letter which the panel has received,
requesting for permission to speak to her. And to date, Advocate Batohi says there was no response from the panel, and therefore she will not be able to continue with her evidence until and unless she receives legal counsel. That is the position that is prevailing at the current moment, Madam Chair and your sisters. That is all I can state for now.
Might I clarify the position with regard to the ministerial response? What presented before the minister was an appeal in the sense of Advocate Batohi appealing the decision, refusing further legal counsel for her, and she appealed to the minister. Correct?
That is correct, Madam Chair.
In relation to the correspondence addressed by Advocate Halley and responded to, among other letters, of course, by Advocate Chauke's legal team, certain legal issues have arisen, correct?
That's correct, Madam Chair.
Has Advocate Batohi been made aware of such correspondence and responses from Advocate Chauke's legal team?
No, she has not been made aware, formally made aware of the response.
Informally?
Informally as well. She has not been, not to my knowledge.
In other words, Advocate Batohi has not had a sight of the responses from Advocate Chauke's team?
To my knowledge, yes, Madam Chair. She has not had sight of that. She has not had sight of that.
Thank you, Advocate Mutlamunyane.
Thank you, Madam Chair.
I suppose what you are saying, in a nutshell, is that Advocate Batohi will not resume where she ended last year, subject to her being afforded what she is asking for, or what she asked for.
That is the position. That is how we understood her letter.
If I may ask you, supposing Advocate Batohi does not take the witness stand, have you decided on the way forward?
We discussed the way forward.
Thank you.
We discussed it.
Thank you.
We discussed it as evidence leaders. Let me be clear on that one.
Yes. Advocate Skosana.
Thank you, Madam Chair.
Perhaps I must just place it on record that whatever you're going to say, you did not mention to us in the chambers.
Indeed so, Madam Chair.
You made an election not to tell us, meaning that it is something that is new to us, what you're going to tell us. You may proceed.
Thank you, Madam Chair. Thank you for the opportunity. And thank you to Advocate Mutlamunyane
for explaining what has occurred so far.
I beg your pardon, Council. Are we inaudible? Just raise your voice and tell us to be louder. You can just raise your voices there so that you can hear what we are saying. We are sorry for that. Proceed, Council.
Thank you, Madam Chair. And thank you to Advocate Muhlamunyane for explaining what has taken place so far. And all I'm going to do is just to address the position of the evidence leaders in relation to the evidence of Advocate Batoyi and what has happened so far. Well, the first thing that I believe is clear is that the evidence leaders are not representing Advocate Batoyi, nor are they acting in the interest of the NPA as such. Advocate Hali SC and his junior Advocate Lekgeto, which I'd call them the NPA legal team, represent the NPA, though we know that they have not been actively involved in these proceedings. Advocate Chauke is represented by a legal team fully and competently. And we know that there was a request, rather, and I'm not addressing the manner in which it was done, during the cross-examination of Advocate Batoyi, that such cross-examination be suspended until she obtains legal counsel, legal advice. And we know Advocate Muhlamunyane has already indicated that there was then a request from Advocate Hali SC for permission to consult with Advocate Batoyi, with apparently with the intention of furnishing such legal advice. And I'm not going to go into the issues about such permission, but I believe it was done on the basis that she is still under cross-examination, and we must note that also Advocate Batoyi was admonished at some point in these proceedings that because she had communicated with some official of the NPA, I believe it's the DPP Advocate Zungu, if I remember well. But we are not onto those issues. What we want to make submission on is that an indication was made that the LPC or Legal Practice Council Code of Conduct would prevent the interview of Advocate Batoyi because she's still under cross-examination by either the NPA legal team or any other legal practitioner. We would like as such, and our submission and our view is that that paragraph of the LPC Code of Conduct does not prevent legal practitioners who have not called a witness to testify to interview that witness.
Ms. Kosana,
Yes.
please allow me to interject.
Yeah.
You are going into the substance of the correspondence, the letters that were exchanged among the parties, correct?
No. That was not my intention.
Well, the point that you are raising as regards the position of the LPC is what has been raised by Advocate Chauke's legal team in response to the letter by Mr. Semelemeja. Is it not so?
Yes, Madam Chair.
That's precisely
what...
I beg your pardon.
Yes.
That's precisely what I'm saying, that you are now getting into the substance of the letters that were exchanged between the parties. And you seek to make legal submissions as regards those letters. And there is no application before us here. Now we are going to make argument in relation to what was raised in the letters between the parties. I thought that you're going to raise something else, but if you are going to make submissions about what was raised in the letters on behalf of Advocate Chauke, that goes into legal issues, isn't it? Correct me if I'm wrong.
Thank you, Madam Chair. Perhaps it does, but what I am addressing here is the position of the evidence leaders insofar as what has occurred so far, and we are simply laying a basis for us as evidence leaders for taking that position. And if it perhaps gets into somehow into the legal argument, that's not my intention to really raise legal issues or legal argument in that regard, but simply to lay a basis for our position as evidence leaders.
Yes, but if you make legal submissions on issues that were raised in the letters, what do you seek us to do with regard to those submissions?
Well, the bottom line, maybe I should go there. The bottom line of what we are saying as evidence leaders is that we think this issue of Advocate Batoyi obtaining legal counsel should be addressed first before the proceedings can go any further, and before any other issues that have already been raised in the letters, in the correspondence, may be addressed. What the first hurdle that you have to go through is this issue of her obtaining legal counsel. I think that's the essence of our position, and I was merely laying a foundation for that. But if perhaps the Madam Chair sees it as perhaps opening other, issues and legal argument, on the aspect when I was dealing with Rule 55.5 of the Code of Conduct, I can leave that out.
Who raised the issue of the LPC?
I believe it was raised during the discussion and correspondence, not even correspondence over the festive, but even earlier correspondence about the rule, paragraph 55.5 of the code, that it would prevent a legal practitioner from consulting or interviewing a witness while under cross-examination.
And that rule is a regulatory position in relation to the LPC that was raised in the letters among the parties, correct?
Yes.
Seek to make a submission with regard thereto?
Yes.
And there is no substantive application before us?
I'm not sure, Madam Chair, a substantive application, we are not making any substantive application. All we are doing is to clarify the position of the evidence leaders insofar as what has occurred and what we intend to do upon receiving clarity. In other words, after Advocate Batoyi has received the legal counsel that she seeks.
Advocate Kosana, you are a senior counsel.
Yeah, but Madam Chair, may I finish as
no,
well?
No.
Yeah.
We can't go around circles about this matter. You raise a matter which is the subject of correspondence between the parties, where a legal issue is raised, you are now making a submission that as evidence leaders, you take issues with the point that has been raised. You don't agree. You don't agree with that submission, with that point that has been raised on behalf of Advocate Chauke. Did I understand you correct in that submission that you made earlier?
Yes, I did, Madam Chair, and I've explained why I've raised that issue. And if raising that issue perhaps is not acceptable to the panel, then I'll abandon it and proceed to make other submissions.
Yes, that's why I'm saying to you, as an SC, you know, you cannot raise a legal argument based on letters. There is no application before us with the specific relief sought so that we can make a ruling or an order. That's why I said, how do you then make a submission on a legal issue when there is no pending application before us, purely based on the letters exchanged by the parties? I thought that you were going to indicate to us a direction, or at least the procedure that you propose that we should consider following last year's unprecedented developments. But you are now raising these issues which are making it difficult for all of us, because those legal skirmishes raised in the letters, we spoke in chambers that we hope that we are going to speak to one another and resolve those issues. But you are now raising it now. You chose not to speak in chambers. Maybe we should have given a direction. So I do not think personally that it's a correct procedure to follow when there's no pending application before us. Perhaps you can just go straight to the point as regards the position that you are taking.
Thank you, Madam Chair. I really don't see why you, Madam Chair, is repeatedly saying that I'm a senior counsel. Of course I am, but the point is, and I know that the panel doesn't agree with me. If you don't agree with me, I've already said I can abandon that portion.
May I
proceed.
just come in here? Just through you, Chair, please. Thank you.
Yes,
Thank you. Just to clarify one thing, so that when you answer, like you are saying that you are aware that the panel does not agree with you on a particular point, but nevertheless you are going ahead, or you are considering abandoning the point. I think it's important to just look at what has brought us here to the point that we are now at. And if one is to try to consider the question that you had, or the statement that you had made right at the beginning, you said an indication was made that the LPC Code of Conduct bars the evidence leaders and the legal team from communicating with Advocate Batoi. We do not agree with that indication. Now, firstly, what I've done has been to paraphrase. I'm not quoting it verbatim. It will be clear on when the records are released as to what it is that you said, but it is something to that effect. Now, once you say that there is this indication that was made regarding the LPC, it's about the interpretation of the code, the interpretation of a particular clause of the code. And once the issue is about interpretation, we know that a determination should be made. There should be an adjudication of that interpretation where one party says, this clause means this, and the other party says, no, it means that. Just by saying, I do not agree with the understanding of that clause, that in itself, Advocate Nkosana, brings about an existence of a dispute about the interpretation. And that is something that appears clearly from the correspondence that has been exchanged, that the issue is about interpretation of that clause of the LPC in particular. And I confine myself to the LPC because you are talking about the LPC Code of Conduct. Thank you, Chair.
May I proceed, Madam Chair?
If Advocate Nkosana, if you want to respond or comment to what I have said, because it's not a question, you may, but if you choose then to proceed with what you were busy with, still you are at liberty to do that. Thank you.
Thank you, Madam Chair.
Yes, Council. Are you responding or commenting to what my sister has just mentioned?
Yes.
If not, my sister, Advocate Baloyi, may want to ask you something. Do you wish to respond or comment to her statement?
Well, shortly, what I can say, there has been a lot that we have been disagreeing with the legal team of Advocate Chauke, and in the midst of what has happened, and us, explaining our position as evidence leaders, we are bound in one way or the other to touch on the points of disagreement. And I was merely dealing with one. I'm not going to deal with all the points of disagreements, and also perhaps what Madam Chair has referred to as skirmishes between the parties. But I am prepared to leave that point, particularly about the Code of Conduct. I leave it out of my address now and then move on to other points. And I believe it's not going to be long, but I can leave that out, yes.
On those issues, in respect of which you disagree, I suppose the position is clear, what you need to do or what you ought to do. Am I correct? Legally speaking.
Well, there may be issues where we need to bring a formal application for a particular ruling from the panel. But I believe that's not what we need to do at this time, at this point in time. And that's not what I intended to do. We're simply explaining what is our position.
With a view to achieve what? I mean, when you mention all these things to us, you mention it with a view to achieve something, because we have the correspondence. We know all these things that you're talking about. We have been copied of the correspondence between yourselves or amongst yourselves. Now you are making submissions about them. I'm not sure to achieve what. I thought that you'll simply indicate to us the position you have taken in relation to these matters, so that if you have agreed between yourselves, then at least it's minus one of the problems. If you still disagree, then you parties, you'll decide what you want to do. I'm not sure why is it that we have to listen to disagreements in relation to matters that are raised in the letters that we have. But you may proceed. Advocate Baloyi will ask you a question.
Just out of interest, Advocate Skosana SC, you seem to take issue with the chair reminding you that you are senior counsel. And my understanding is that she's doing it purposely because you are leading a team and you should lead by example. I'm not sure why do you take issue with being reminded that you are here as a leader. Is there an issue so that maybe we shouldn't do the same next time? Because I know I have a tendency of just saying or just reminding someone that you are here and you are leading and you should lead by example and you should know the rules better and you should know the procedure better. Because right at the beginning we issued rules of procedure where parties were informed on how to deal with issues. You deal with issues amongst yourselves. If you don't agree, you bring a substantive application and we make a ruling. Thank you.
Thank you. What you are saying, Advocate Baloyi Mere, SC, is that actually, to me, also emphasizes my, the way I understood it. When somebody says to you, you are a senior counsel, you should know this. It seems you are saying you're not doing your work properly. You are supposed to know this, yet it appears that you don't know it. And I'm simply saying, I'm making submissions, and they relate to the position of the evidence leaders. You may disagree with that, of course, and disagreement is in the nature of proceedings. But I find that submission, that remark, to me, I must say, unacceptable. And I'm sorry that this now again happens in the public arena. But I don't intend to be disrespectful. All I'm saying is that that was my understanding, that when you say you are a senior counsel, yet it seems that you don't understand this basic rule. I want to put it that clearly that's why I reacted in the way that I did. But if I may proceed.
Before you proceed,
yeah.
Advocate Skosana, we all had an opportunity this morning where matters were discussed in chambers. Of all the parties, you are the only one who decided not to tell us in chambers on all these things that now you are placing on record. And perhaps these matters would have been discussed in chambers without being discussed in the public domain. As we lawyers speak, that opportunity was presented to you, but you made an election not to discuss it in chambers like what everybody else did. It cannot be correct now for you to say this thing is being discussed in the public domain when you had an opportunity, as we all discussed in chambers, so that you could understand your position. But you decided not to say anything. You said you want to place it here on record in the public space. We would ordinarily discuss it in the public space because we are transparent. But we discuss amongst them ourselves as lawyers so that we come here knowing precisely what we're going to talk about. You may proceed.
Yeah, I think I've said what I needed to say. As far as our submission and our position as evidence leaders, we are saying at this point in time, Advocate Baloyi has indicated her unwillingness to proceed without having obtained legal advice. And I want to emphasize that the unwillingness, the term unwillingness is used advisedly. In other words, it's not unqualified unwillingness, as it has been portrayed in some media publications. It's unwillingness on the basis that she still needs to obtain legal advice. She requires that advice in order to verify her legal rights and interests, which may well include her constitutional rights, whether they are secured in the light of the manner in which the cross-examination has proceeded. Once duly advised, she will then make that call about continuing or not continuing with her testimony. What I believe and what we believe as evidence leaders may be in question is how long that would take. But of course, our solace is in that, or let me leave that part, because it may take us back to the same question. Now, our position is that all the other questions are dependent, or maybe dependent, on this one. In other words, they cannot be addressed meaningfully without or before this one of her obtaining legal advice is determined. If Advocate Batoi, after obtaining the legal counsel that she requires, then communicates that she still is not prepared to continue with her testimony, then the evidence leaders will have to make a call, taking into account the powers of the inquiry with regard to the power to subpoena and so on. Then the evidence leaders must decide whether they want to take any legal steps to compel her to continue, and if so, what steps? Of course, if no legal steps are taken, then the evidence leader will have to decide then what further evidence they need to lead. And I think there are questions that have been raised by Advocate Chauke's team, legal team. But then those questions can be argued after that point has been passed. One of the issues that have been raised, and I'm not addressing it, is whether or not she can return to testify. I'm not sure even that they still pursue that, but that was raised. But we, as submitting as evidence leader, that can only be entertained after she has decided whether or not she's returning. Otherwise, the inquiry will be considering, questions which are based on a qualified decision of Advocate Batoi instead of an absolute decision, an absolute one. And the other question that has been raised is that if, by the legal team of Advocate Chauke, is that if she does not return, whether there will be, so they say, an irredeemable evidentiary deficit in these proceedings. That question will also, in our submission, will also be and can only be addressed after she has decided whether or not she is returning. We want to also mention that, at the previous hearing before the adjournment, Advocate Batoi was crudely reminded that her conduct could have serious consequences, which is legal consequences. But we submit that she can only weigh that up, or weigh up those legal repercussions by having access to legal counsel who are also allowed to speak to her. So that's, in essence, our position as evidence leaders, that we think it all centers around whether she is granted that permission and the opportunity to consult and to obtain that legal counsel. And thereafter, then all other issues will follow and will have to be determined if they are still in dispute. That's the essence of what I wanted to present on behalf of the evidence leaders.
Advocate Skosana, you said you're going to present the position of the evidence leaders. And right at the beginning, you told us that and rightfully so, that the evidence leaders do not represent Advocate Batohi or the NPA. And you are not here in the NPA's interest. You are here to present evidence from all quarters, all walks of life, as long as the evidence is relevant to the inquiry. But what you've presented to us when I was listening to you, unless if I'm wrong, and if I'm wrong, please correct me, is you are giving us all the obstacles that Advocate Batohi is facing without giving us your position as the evidence leaders, because I had expected that you would have thought, or should I stop there? Thank you.
You may switch off your microphone.
Okay. I had expected that we were all here on the 15th of December. You are the evidence leaders. You are the drivers of this inquiry. So from what happened and the request that Advocate Batohi made for legal representation and all the obstacles that she met along the way, that would have triggered or made you as evidence leaders to think about the way forward, multiple probabilities. What happens if Advocate Batohi does not get evidence leaders and she decides she's not proceeding with her evidence before she gets legal representative or legal advice? And what do we do in the meantime? And we are all here in the interest of the public. Now, what do you do as evidence leaders to make sure that the inquiry proceeds with its work? Or you come here, you give us your position to say, seeing that Advocate Batohi is not continuing with her evidence, we as evidence leaders, we take it, that's it, this is it. We are stopping here, no more inquiry. I expected that the evidence leaders will be, when you said you were giving us your position, you'll come with a guiding position and trying to give a way forward. Now you are telling us that no, even all the other questions depend on the advice that Advocate Batohi is going to get, meaning should Advocate Batohi not get her advice, we may not be able to proceed. Or should it take time for her to get advice, we'll have to stop and wait for that. You are not giving us a way forward, a position that can help us to go forward. Instead, you are giving us all the problems that Advocate Batohi is facing, and also not even giving the solution. I expected that the evidence leaders will be guiding and will be assisting this inquiry going forward. Thank you, Chair.
Thank you, Advocate Baloyi Mere. We as evidence leaders, and I think correctly so, you stated we don't represent the NPA or Advocate Batohi. But also as evidence leaders, I think we're tasked with a duty to bring evidence to this inquiry, and from all quarters, whether it favors or the NPA, or it favors Advocate Chauke. But also, part of our duty is to try and ensure, insofar as we can, that the evidence that is brought before this inquiry is evidence that has got value, evidence that is brought forward in a proper way. And we have examined, as evidence leaders, the position of Advocate Batoi, who has been called by the evidence leaders to give testimony. She has put it plainly what her position is, and that she requires that counsel. And we are merely expressing our view and our opinion that that issue ought to be resolved in whatever way. First of all, it must be given an opportunity. She must be given an opportunity to consult and obtain that legal counsel from whatever court does, whether it be from the NPA legal team or any other legal team. But that has to be dealt with. That is our position as evidence leaders. And we, of course, will have to address, and I've said it already, that we'll address only upon establishing that position, upon her returning after obtaining legal advice, whether she intends to continue with her testimony. And all the other issues that will have to be addressed, including the fact that what should happen now to this inquiry. Are you, as evidence leaders, in a position to lead further evidence? Do you intend to lead further evidence? And the circumstances surrounding that. That is our position as evidence leaders. I don't know if I've addressed your question, Madam.
Thank you.
For progress, let us assume, Advocate Skosana, that Advocate Batoi decides not to take the witness stand for the reason that she doesn't have her personal legal representative. I use personal because I know, all of us know, that Advocate Haley has been acting together with the junior, of course, as the team for the NPA, correct? The NPA, which, if I may use that, is Advocate Batoi, because she's a leader of that institution. She seeks legal counsel, her personal legal representative apparently, to seek legal advice on issues that are not before us. Am I correct? We don't know what she wants to be advised on. Am I right? Or maybe you know. As far as we are concerned as a panel, we don't know.
No, we do not know the details, Madam Chair, yes.
Neither do you know as evidence leaders. We have just been told that she must now be afforded an opportunity to be given legal counsel. And we know that Solicitor General has declined her request. She appealed to the minister. The minister declined her request on the basis that NPA, which she leads, is before us. Now, in the absence of an application in which we will be told what issues she wishes to pursue, if we were to make a decision, on what evidence are we going to make any such decision? If we don't even know what she seeks legal advice on, maybe you can advise me there?
Well, Madam Chair, I think it's quite a secular question, because at the same time, as evidence leaders, we are convinced that, at least as evidence leaders, we are not allowed to consult with Advocate Batohi at this point in time, and while she is under cross-examination. So
But you are answering a different point. I'm simply saying, if she is indeed entitled to a legal representation, personally, I think a matter that probably the minister was not asked to consider. What is the essence of that request? What is it that she seeks legal representation on? Because we have to take each other's, and she has to take us into her confidence, at least in an application. The letters that she wrote, which we did not respond to, because a panel is not in the business of exchanging letters with the parties. If we are asked to make a decision, it must be on an application. It is then we have all the facts by all the parties. We have legal argument by all the parties, then we can form a view and make a ruling. Now we don't have anything in front of us. But we take note of the position that you as evidence leaders have taken. And as my sister advocate Mary SC has said, your role as evidence leaders must decide on the process forward. Because without you, this inquiry will come to an end. You have given us a list of witnesses. If she's not going to testify, supposedly because she has to pursue her request, you should be in a position to proceed with this inquiry and lead further witnesses, at the very least, so that we can make progress. But it cannot be that we are told that if Advocate Batohi does not get a legal representative, you will not be in a position to proceed as evidence leaders, because you are not acting for her, neither are you acting for NPA. You are here to assist this inquiry, and at least to gather all evidential material that may assist us in the task we have been asked to perform. I assume that you will decide when we adjourn as to what position you are going to take in that regard. Not as speaking for Advocate Batohi, because we don't have any application here. And if she takes the position that she's not going to testify, when the minister has taken a decision, are we in a position as we speak to say to the Solicitor General whether there are funds or no funds, appoint a legal team for Advocate Batohi, or even to the minister? What will be the basis of that decision without anything being presented to us? So I don't want us to exchange with you because you are not even representing her. You are an evidence leader. You must assist us as the key leaders of evidence on the way forward. If you think that you will not be in a position to call any of your witnesses in the meantime, because progress is what we have to make here. We cannot not go. Now we spend almost half a day talking about the interest of Advocate Batohi, which we all understand. But a decision must be taken. If she decides not to take a witness stance, that will be her choice. If you think that that is going to make your case difficult, what would have remained after cross-examination would be you leading further evidence in re-examination. If that does not happen, then you can call another witness, because we all know what her position is. We will all know what her position is. So please discuss this matter with Advocate Mutlamuyani and your team regarding your position as evidence leaders, not as evidence leaders presenting the case for Advocate Batoyi, because we don't have anything in writing here other than the letters. I would like to ask some. Any?
Well, you know, at the risk of repeating myself, I think what I was placing before this panel is the position of the evidence leaders, which we have discussed, and we have said this is the position that we take so far. We're not yet at a point where we're dealing with the leading of further evidence, but we're dealing with the position that this inquiry finds itself insofar as Advocate Batoyi is concerned. That was our position in that regard.
But of course, you may switch off. As I mentioned, you now know the position of this panel. If you decide to proceed, you may confer with one another as evidence leaders as to what you wish to do. If Advocate Batoyi decides, because the choice is hers, if she decides not to proceed, she's not represented by Advocate Hali, and if she feels that she's being put in a disadvantage, she will indicate so. But I don't know how we are going even to make a determination of the disadvantage without any evidential or facts being placed before us. That's a very difficult situation. So what I'm saying, Advocate Skosana, is that you will take a position as evidence leaders on the way forward of this inquiry. And it means when we adjourn, after my sister has asked the question, we will afford Advocate Nkabinde to confer with his team, and we will reconvene, because I'm sure he's taken by surprise on these matters that we are engaging with you. And he will come back and indicate what his position is. And if necessary, in the event Advocate Batoyi would like to talk to us, she's free to do so. She may even communicate to you as evidence leaders who brought her here. And if she decides to take the stand, she's free to do that. Let my sister ask a question.
Yeah, thank you, Chair. Mr. Skosana, you know, when I was listening to you about where this issue stands, I gain an impression that you are saying everything revolves around the question whether Advocate Batoyi secures counsel for advice or not. Is that understanding correct? My understanding that everything revolves around the question as to whether she secures advice from the legal representatives or not. Is that understanding correct or wrong? And if it's wrong, just correct it so that we can move together side by side on a common understanding. Thank you.
Well, perhaps, maybe I may put it this way, that we as evidence leaders think it is important at this stage to resolve that question first. Not that this whole inquiry and the proceeding depends upon that, but that question should be resolved. Of course, we are mindful of time, and that's why I said in my address that also the question is how long that would take. That question be resolved whether or not she intends to come back and testify. And that can only be resolved after she has received that legal counsel.
Yeah, so actually my understanding that everything revolves around that, it's wrong. It's slightly wrong, ne?
Yes, I don't want to say you're wrong, but I think I've clarified it, yeah.
No, then that's fine. It is now common knowledge that Advocate Batoi appealed after her request was turned down by the Solicitor General, and the Minister has also rejected the appeal or turned down the appeal. Am I correct?
That is so.
Advocate Batoi has an election to insist. I don't know what comes beyond appeal. I'll ask you that because you are acting on instructions by the State's Attorney. That after the appeal of the Minister, is there still anything that can be done within the perimeters of the Department of Justice? Can you assist with that?
Well, Madam Ramahaha, I'm not sure if there's anything that can be done on the side of the department, but what I can say is that this question of the possible conflict of interest with Advocate Harley and her junior only arose now. We must remember that when the instruction or when she was disallowed to appoint a new counsel to advise her, and when the NPA legal team was appointed as the ones who should give her the advice, that issue had not arisen. Actually, we have a letter from NPA legal team that says, can the panel grant them an opportunity, or a permission to consult with her while she's under examination? Now, this has arisen afterwards, and I also see it, and it's correct, that there's actually a conflict of interest. I am not sure whether the minister or the department in the appeal, that has been considered, the question of conflict of interest. Those are the issues that will still have to be resolved before we can determine finally the issue of her obtaining legal counsel.
Sorry, Madam Chair, if I could, I apologize, Madam Ramahaha, but Mr. Harley has a real problem because he's not allowed to make submissions. But he appealed to all of us not to raise this issue because he has not yet canvassed it. So I just thought, let me put that on record. I apologize.
And Advocate Kosana, you are aware of that? You are aware of the fact that this matter that you are raising regarding Advocate Harley was not supposed to be brought here?
Well, I think the panel already alluded to it and asked me questions about it. So I'm not sure if you say I did not really bring it here.
Which questions?
The question that Madam Chair is raising about the conflict of interest.
Did I
I thought-
mention any conflict of interest, me? You're the one who has just answered to Mera Machacha, as you were answering the question that because of the conflict of interest with Advocate Halley. And this is the reason why Advocate Nkabinde is interjecting. And as we came here,
Yeah.
Advocate Halley made it clear that all the matters that were raised in chambers as regards his position and his juniors should not be discussed here. And now you are raising them. Am I right?
Well, first of all, I spoke about potential conflict of interest, possible conflict of interest. But in any event, I understood that question to already have been raised by the panel, because when in the middle of my address, that issue that Advocate Halley is actually representing only the NPA and not Advocate Batohi in person, although she's still an NDPP. That question already arose, and I addressed it in the way that I could. As to whether that has not been formally raised, that's another issue. And I understand that Advocate Halley might be given the opportunity to explain that. But I raised it in the context of the panel having alluded to that.
If I may just jump in, Chair, I'm sorry to do this, but Advocate Skosana, if I may remind you, and I hope the record will be able to bear me out, the Chair referred to Advocate Halley and Advocate Lekgetho as the representatives of the NPA, and she said, although I'm not quoting her verbatim, but she said, which in essence includes Advocate Batohi because she represents the NPA. And I think that's as far as it was taken. She leads the NPA. That's as far as it was taken. It was never taken beyond that because we understood that Advocate Halley has not briefed Advocate Batohi. And also on a question that was posed to you, which you answered positively, that the correspondence and the response from the Chauke team was never brought to Advocate Batohi's attention, whether formally or informally. Meaning, as we speak now, Advocate Batohi might be in the dark and she might need to be briefed before certain issues are discussed in public. And that was my understanding, that we as a panel did not raise any issue that was not supposed to, or that was not ripe to be discussed here today before there has been a consultation or there has been a briefing between Advocate Halley, Advocate Lekgetho, and the NPA and Advocate Batohi. Thank you.
I had asked was a very simple question. And that question was whether, seeing that the Solicitor General has not approved the application as informed, the Minister has not upheld the appeal, is there anything else that can be done? That was the question now that brought this whole lot of things that it's a very simple question as to whether, in light of that, in light of the processes, and I ask you this question because you are acting on instructions by the state attorney, and the state attorney is the one that has their own processes in terms of affording or funding legal representations of people. So your answer, in a nutshell, is what to the question, whether beyond the appeal, there is anything else that can still be done by the Department of Justice. You remember that question?
Yeah.
Yes.
Yeah, I remember that question, and the prelude to my answer was that no, I do not know. I do not know what else the department can do. Then I added the remark after that.
Right, thank you. Do you agree that the Advocate Batui is not barred from obtaining legal representation through her own funding out of pocket? Is she barred from doing that?
As far as I'm aware, no. Yes.
Can she also seek legal aid if she qualifies?
Well, Madam Chair, yes. If she qualifies, yes. I'm not sure about the rules around the legal aid. My little knowledge would say that she would not qualify, but that's under correction.
Yes, that's why I'm asking, that she has been refused legal representation by government. I'm told, or I read, because of financial constraints, and if she wishes to pursue her position, bearing in mind that she's a witness, just a witness, will she be entitled to approach legal aid if she doesn't have her personal funding? If she qualifies, of course, I mean, she will have to ascertain that herself. I'm asking you as counsel.
Yes, certainly, Madam Chair, if she qualifies, she may obtain legal aid, yeah, funding.
I'm done, thank you. Thank you, Chair.
Matter of procedure. Given the position that you have taken as evidence leaders against the backdrop of the request being refused, not once, but twice by the government, if I may put it that way, and the fact that you say, as we speak, you are not in a position to proceed without her being afforded legal representation. What is it that you think we can do as the panel?
Well, Madam Chair, I believe, and it's subject to what Madam Chair has already said, that there should be a proper application. That opportunity be granted to Advocate Batui to secure that legal counsel. Of course, it will be within confines of time. That would require, of course, from us as evidence leaders, and that one we have not discussed with evidence leader, whether that would require us to bring a formal application for an adjournment for that period, whether it be a day or two, so that can be done. But that application has not been brought. We're merely presenting our position.
Yes, that's why I'm asking you. Apart from what I said, based on the submissions that you have made now, I'm asking you, sitting where you are, what do you think is the solution to this conundrum? Without me dictating or directing, we have not issued any direction. I'm just asking you questions that, in the absence of any facts, that tells us the basis on which the request has been made to to the Solicitor General, and to the Minister. What do you think we can do as a panel, given that scenario? Without me saying to you, we think that there must be an application as evidence leaders who has made submissions in that regard. What do you think is a solution?
Well, at this point in time, and having heard the view of the panel on this, I think we'd need to ask for an adjournment for us as evidence leaders to take the position whether we want to bring such an application or not. I have already indicated what we, in our discussion, thought should happen, and it may be that the panel does not agree with our thinking and our submissions, but we have indicated what our position is, and would then, now having heard what Madam Chair is saying, have to take a position what should happen, whether we want to bring an application for such adjournment for the consideration of this question of Advocate Batoi obtaining legal counsel.
You know, Councillor, I don't want to belabor the point, but I would like us to understand each other or one another. You made the submissions on the basis that you will not be in a position to proceed pending or subject to Advocate Batoi's request being granted or something to that effect. That is the current position that you take as evidence leaders. And I ask the question, even yourself, you don't know what is it that he bases that request on. You said so earlier. Because if somebody says, as a witness, I'm no longer proceeding because I seek legal representation, but she does not really tell us or take us into her confidence to say, what is it that she thinks will guarantee or warrant such a request being considered favorably? In other words, how do we make a determination, if we were to make a determination on such a request without being taken into her confidence? You yourself don't know. I'm sure the minister doesn't know either. The request has now been refused by those who provide money, and we are now told that something has to be done for her. But then the question is, what is it that warrants that request being granted without any evidence, any information that may persuade us to say, Minister, reconsider your position? I don't even know whether we are entitled to do that. But the question then remains, in the event such a request is considered, as you say, you want to make an application, or you are going to consider to make an application, we should now grant you a postponement. There's just another delay on a matter that relates to a witness who seeks to, I suppose, to protect her interests. But you don't know precisely what is it that she thinks she has been prejudiced on. It makes it so difficult for us. And then the question then arises, and I said earlier, do discuss it with your colleagues about your position, because your role is to assist us and not make our task difficult. As it is right now, we cannot proceed with this inquiry because of the position that you are taking. I thought that you'll say, if Advocate Batoi verily believes that she's been disadvantaged by the refusal to grant her legal representation, we, yourself as evidence leaders, to bring this matter to finality, we will, in the meantime, bring another witness to make some progress. But now you ask us to pause again. We paused for more than a month. A delay for this inquiry to be finalized. Now you are asking for another 2 days to go and consider whether you want to make an application. I find it very difficult to understand as evidence leaders because you have given us a list of witnesses. Perhaps you should consider, and I'm just thinking aloud. I am not telling you how you should run the matter. Perhaps you should consider, in the meantime, for progress, to call the next witness whilst Advocate Batoyi is considering her position, whether she can expend her finances or approach legal aid, because government has refused her legal representation personally. If you were to make an application and seek a specific relief, what relief, if I may ask you, what kind of a relief are you going to ask? That we tell the minister to provide money for her, for legal representation? Or what kind of relief are you going to seek? Advocate Kosana, I don't know what the right answer is, but probably you may assist us. If you can't, you will confer with your team so that we try to engage with one another to find a solution to this difficult situation that has been presented to us.
Yeah, thank you, Madam Chair. I appreciate that and the difficulties, and in the midst of that, I want to also mention that part of the difficulty is our inability to consult with her. We don't have details of her basis for seeking legal counsel, because we may, as much as the NPA legal team was not able to consult with her, then for a stronger reason, the evidence leaders are not able to consult with her while she's under cross-examination. So we were not able to get to the depth of her thinking and why she felt that way and decided to seek legal counsel. And of course, that legal counsel would include the question whether she needs more time. I think that counsel, we may not prejudice that counsel by now getting into the issues of whether or not she should continue as evidence leaders. I think we may not get into that question. Ours was to lead evidence of the witness and to try and ensure that that evidence is led in a proper way. And to some extent that also her right as a witness now, not as NPA or NDPP, but as a witness, are protected. Thank you.
In the letter that she wrote to the Solicitor General, I beg your pardon, to the Solicitor General and to the Minister, did she disclose all these things that we say we are not aware of? Even if she doesn't consult with you, did she have an opportunity to present to the Solicitor General and to the Minister? What is it that she thinks entitles her to a separate legal representative? Because at least even if you don't consult with her, in the letter to the Minister, she could divulge all this information which could be assisting us, because we have the correspondence. That is an opportunity that she has. If she were to write in details to them to reconsider their position as the ministry, if she present all the information to them. of anything in the letter that was disclosed to the minister that gives the substance of the request?
Madam Chair, that information was not divulged to us. We were not finished with a copy of the letter.
You are, however, aware of this correspondence that we all have that has been exchanged even by Mr. Ndate Semelemecha.
Well, Madam Chair, we are aware that she sought the funding of a council from the Solicitor General, which was refused, and she was directed to use the services of the NPA legal team, and she then appealed to the minister, which appeal was then dismissed. That's all we are aware of. We don't have the details on the documentation itself of that application.
Nothing debars you from communicating with Mr. Semelemecha with regard to that correspondence or all the facts that were presented to him and subsequently to the minister as to whether she explained the reason why she thinks that she's entitled to a personal legal representation as a witness.
Well, Madam Chair, we'll inquire from Mr. Semelemecha. As far as we are aware, Mr. Semelemecha always copies us if she receives correspondence, whether from Advocate Batoi, from Advocate Chauke's team. She communicates, she gives us copies. In this case, or in relation to that, we did not see any correspondence. But I will inquire from him whether he had any access to such correspondence.
Well, he is an instructing attorney here, the Solicitor General. And he must have based his decision, or the state attorney's decision, on the basis of something. The minister, too, must have based her decision on something. And it is therefore that I'm asking you to confer with him. He is your instructing attorney. Then you can get all that information from him. And if such information was presented, which we are not aware of, because we don't have any facts, it may well be that Advocate Batoi presented something that has not been brought to our position, that if you were to apply, you may include in that application. But I'm not very sure whether the relief that you'll seek will be such that may entitle us to direct the minister to afford her legal representation. That's why I was asking you, if you were to apply, and I'm just asking you to assist us, if you were to apply, what kind of a relief are you going to seek, given this background?
Well, Madam Chair, I think I've already tried to answer that question. We have not yet brought the application, of course, and we will consider what Madam Chair is saying, but I think part of the problem is that we also don't have facts precisely for the reason that we are unable to consult directly with Advocate Batoi. But we will consider all that has transpired now and also consider, we have not even, I have not discussed with my team whether we will bring that application as evidence leaders. But we are going to consider that now. Yes.
Advocate Traitobi, I suppose it's the right time to pause to enable you to consider your position as regards the matters that we have been engaging with Advocate Kosana on. And when you resume, you will then present your position, covering all the facts that we have been raising with him, because we don't know what the right answer is. We are all taken aback. We don't have answers, and we don't know what kind of ruling or direction we can give in the circumstances, and we will take the matter from there. This,
I presume.
I beg your pardon.
Thank you, Madam Chair.
I beg your pardon. This will also enable all of you, if need be, to confer with Advocate Halley, who's representing the NPA. These are not simple matters to simply discuss, like we are just having a discussion on a matter where there is no application. And that's why I'm asking counsel, given all the circumstances, even if you were to go the route of a substantive application, what kind of a relief would you people ask us to consider? And secondly, whether there is sufficient evidential material presented either before the Solicitor General or the Minister that we ought to consider, even aside of a substantive application. I know that you may not have such information, but if there's anything that can be brought to our attention, probably favorable to Advocate Batohi, it should be brought to our attention. That Ismail Mecha is here. He signed one of the letters, and he's better placed to guide the evidence-leading team. To that end, I think the right thing is to pause for 30 minutes. If you are still discussing within that 30 minutes, do send a message. Then we can grant you more time to confer with one another. Remember, we mentioned that at Chambers, the legislative imperatives to have this inquiry finished as soon as possible. We don't have time on our side. 12 months is going to expire very soon. And we cannot be seen to be arguing about these interlocutory issues when we are supposed to get to the heart of the matter. Because we are all here to investigate and bring all the facts. It's not about Advocate Batohi being, he's not an accused, or he's not in a position of Advocate Chauke. He's just a witness. And if she thinks that she's been prejudiced, she knows what avenues are open to her. But let's proceed. As you go out to discuss, bearing in mind this legislative imperative, we cannot waste more time. In fact, we committed to the minister that we may have to sit on Saturdays, given the list of witnesses that you people have given us. But if you are seen to be delaying the matter any further, it's going to be very difficult for us, because we have to prepare a report at the end of the inquiry, and we may not have sufficient time to do so. So I'm mentioning it to all of you, not necessarily to you, Advocate Nkabinde, that let us work towards finality to enable us to discharge our task. We will adjourn until, I beg your pardon, yes, sir?
No, Madam Chair, I just wanted to ask how long, but I think you've answered that.
Take 30 minutes. We could use that to have tea if we've been supplied with tea. It appears that the ministry doesn't have money anymore to give us lunch. But we are told that we will be served with tea. Everybody here, the media, we are told that we'll only be given tea, all of us. But let's see what would have been offered. We should be thankful for what they are giving us. We all know that finances are tight everywhere. Let's go and have tea. We can reconvene at 12:10. If you still need more time, send our researchers and tell us how much more time you will need, then we will reconvene. Yes, thank you. We will adjourn for 30 minutes. Good afternoon, everyone. Advocate Nkabinde.
Thank you, Madam Chair. We are grateful for the indulgence. We discussed the matter internally as well as in collaboration with the evidence leaders. Perhaps the best way is to allow the evidence leader to explain the position they finally settled on. Thank you, Madam Chair.
Thank you, Counsel. Advocate Nkosana.
Thank you, Madam Chair. We, as evidence leaders, have considered this matter and decided, in view of the deliberations that have occurred today, to bring an application. And the application would be for the adjournment of these proceedings until, from what we have discussed so far, until Monday, the coming Monday. And of course, that application will contain the basis and the reasons why we're bringing that application. The time frames and the timetable for exchange of papers between the parties may be discussed, but we do need to bring that application. I may indicate at this stage that in broadly, the application will be on the basis of addressing the issue of the potential interest. And I emphasize the potential interest, conflict of interest, And in regard to Advocate Harley and the NPA team, legal team. And number two, the reasons will be relating to the list of witnesses that the evidence leaders has provided and the challenges that they've experienced in that regard. So they would, in broad, there'll be those two reasons in the application. There may be more, but those two will be there. I just wanted to give the panel an indication in broad terms what that application will be about. Yes, Madam Chair, I think I can stop at that point for now.
Yes, thank you, Counsel. The first aspect of that application relates to a potential conflict of interest in relation to Advocate Harley, you said?
Yes.
And the application will be brought by who?
By the evidence leaders, Madam Chair.
The second aspect relates to, you said the second aspect relates to the witnesses.
Relates to the witnesses, the list of witnesses that was provided and the challenges that have been experienced so far by the evidence leaders.
All the witnesses that you have provided us with, you have challenges in relation to all of them or some of them?
Well, some of them, Madam Chair, yes. And we must indicate in particular in relation to this aspect relating to the Katomena unit and Major General Poison, and the like. That's all those witnesses so far. The Katomena unit, as well as Major General Poison, witnesses will be testifying in relation to that, in particular, that aspect. We have experienced difficulties and will explain in the affidavit that we intend to file the kind of difficulties and why we think it is necessary to complete that part of the case before going to the second aspect, which relates to the Mdluli case.
Just to clarify so that I understand, you said you have considered and decided to bring an application for these proceedings to be paused until Monday next week.
Yes.
So should I understand that what you are saying is we stop until next week Monday, or you bringing an application? When will you bring the application? It's a bit confusing for me.
Yes, thank you. I think you are correct that I didn't indicate exactly. I said the timeframes, of course, may be decided, of course, with the guideline of this panel, the timetable for the exchange of papers in that application and the hearing of that application for postponement, because we would like to bring it formally on paper.
Sorry? Meaning that while the exchange of papers is happening, the inquiry would have paused,
Indeed.
According to your suggestion.
Indeed so.
And of the witnesses that you have listed in relation to the Katomena case, who are not giving you challenges, aren't you in a position to at least consider calling any of those witnesses whose position is not challenging for you, so that we can make some progress?
As I'm aware, as far as I'm aware, and upon discussion with our team, we think we have a difficulty with all the witnesses relating to that aspect. That is now the Katomena and Major General Poison. Perhaps when I said some, Madam Chair, was dividing between the one aspect and the other. The Mdluli matter, yes.
As regards the Katomena matter, all the witnesses listed by yourself as evidence leaders are giving you some challenges. I'm not sure what those challenges are, but you seem to be encountering challenges with them.
Yes, Madam Chair. I don't want to find myself perhaps, making a contradictory statement at this point. We will do our best to give as much detail as possible in the application, which will be brought. I believe there will be affidavits in that regard, and explain exactly what is happening, what kind of challenges we have experienced as evidence leaders.
Yes, I understand. The reason why I engage with you is to ascertain a possibility of us proceeding at least with any of the witnesses who may not be giving you challenges as far as the Katomena is concerned, so that at least we can tick off those witnesses, because we have a long list. And I'm not sure how we are going to proceed when we have expended closer to more than a month on one witness, and we are not even done with that witness. So assuming that you understand our predicament as a panel, and you as evidence leaders, because your role is very critical for our functioning. If you have any other witness, some of them you have consulted with. I remember at one stage, Advocate Mchweni was excused upon his request to go and consult with some witnesses, yourself too, counsel. And if any of those witnesses are ready, that's why I'm asking you questions. If any of those witnesses are ready and we can probably deal with their evidence to make some progress, shouldn't you consider, unless of course, as you say, seemingly, all those listed witnesses are presenting challenges to you? If that's the case, then maybe we should leave it there. And you'll explain to us in your application what the challenges are and why we cannot proceed.
Yes, Madam Chair, from our discussion as evidence leaders, we have a challenge with all the witnesses, and it's different kind of challenges. But we were able to conclude that at this stage, we are not in a position to call any of those witnesses. We appreciate the predicament and the time constraints.
I beg your pardon. If we are minded to consider this application or your request now favorably to postpone, have you considered the time frames within which certain steps will be taken by yourself and the other team, and then yourself in reply if need be, and the filing of written submissions?
Well, Madam Chair, we have not considered it with the Advocate Chauke's team. However, as evidence leaders, we did contemplate that we should have the application heard by this panel by latest Thursday or latest Friday this week, after the papers have been filed, including the submissions, if any, legal submissions.
No, I'm talking about time frames. With time period within which application should be lodged, if you were to give directions, ordinarily the parties should have agreed to that and present to us a consent document saying you will lodge your application on tomorrow afternoon, for argument's sake. They will file their reply, the answering affidavit by Wednesday afternoon. You'll consider your reply, if any, by Thursday. Written submissions may be filed simultaneously by the parties, something to that effect, to ripen the matter. That's what I'm asking.
Well, Madam Chair, we are prepared to do that. One, that has not been done formally. I think there were informal discussions, and I may be corrected by Advocate Nkabinde. There were some informal discussions around that, around the timetable when papers can be filed. But we did not, reduce that to writing. We, in any event, also wanted to hear what the panel's view is on that, and perhaps to get guidance, because whatever documents we will draft will have to receive the approval of the panel.
The Katomena witnesses who seem to be giving you challenges, if we were to say, let's leap into the next issue in relation to which the witnesses are not giving you problems, can't we do that? Is it possible? The Mdluli matter.
Well, I'll answer it from I haven't discussed that with
I think you can confer with your colleagues. I don't want to take you by surprise. You can confer with your colleagues if you wish. Yes.
What I wanted to indicate, Madam Chair, is that also some of the developments with regard or the challenges that we have experienced are things that have arisen of late, as late as last week Friday and so on, and the panel will see that on our affidavits. But nonetheless, I can confer further on the question that is now on the table, what I've been asked.
No. You indicated earlier that as far as the witnesses are concerned, the challenges you have encountered are in relation to the Katomena matter. That begs the question as regards the Mdluli matter. If the Mdluli matter witnesses are available to be called, shouldn't that be considered?
I don't know whether I should start by code. I just want to, maybe I should confer with my colleagues here before I answer that question.
I think that's the right thing to do.
Thank you.
Council, if you need a bit of time to confer with one another, we can adjourn for a few minutes so that we can talk about this. It's critical. It's critical in the sense that we need to make progress here. And if we cannot make progress, at least we have to understand that it is something beyond our control, at least as a panel. But if the challenges are with the evidence leaders, it will be understood as such. So that's why it is important that you and your team should seriously consider what is possible in relation to calling other witnesses to make some progress. It cannot be seen to be, this matter was postponed for a month, almost a month in December. I don't want to go back there, but so much time has gone. We don't have much time now. And I really wish that all of us must work towards progress. So if it is possible, we should continue. If it is not possible, as you would tell us, you will let us know. That's why I would like you to have much time to consider all possibilities so that we can make progress. Do you need time to confer and discuss this matter in relation to the Mdluli matter, or you have finalized your discussion?
Sorry, yeah, we need time, Madam Chair. We'll request then a short adjournment just to finalize that aspect and our response to that.
Before we hear Advocate Nkabinde, my sister has a question.
Thank you, Chair. Advocate Skosana, the first reason why you are seeking an adjournment is for the panel to afford you the opportunity to bring an application to this panel which seeks to address the issue of the potential conflict of interest. Am I correct?
Yes, I said so, yes.
You said so, and that is the case?
Yes.
Right. Now, whatever the grounds that you may bring to the attention of the panel, maybe let me withdraw that question and ask this one first. When you make this application, specifically with the intention to bring the issue of conflict of interest to the panel, what is the ultimate goal? Is the ultimate goal intertwined with the question of funding legal representatives for Advocate Batohi, or are they divorced from each other? Of importance to me is to just understand as to whether this issue of bringing the application to show us the conflict of interest, is it being brought with the ultimate view or ultimate intention of addressing the issue of funding Advocate Batohi's personal legal representation, or what is the position?
Well, perhaps to say it is, maybe I didn't articulate it as I should. The issue that will require an opportunity to address may actually answer may be yes and no, because it involves, yes, it might involve the issue of funding, but essentially as to whether the NPA legal team is or will experience that conflict of interest. And it's not to tell the panel whether or not there's a conflict of interest. The question, the ultimate question, is of course whether Advocate Batoi can receive that legal advice.
I'm trying to ascertain as to what the first question is meant to address. So what you are saying is that that issue of conflict of interest, that application concerning the conflict of interest, is made to obtain what information whether Advocate Hali may consult or advise Advocate Batoi or not. Is that the aim? And correct me if I'm wrong, so that we save time.
Well, it's to establish whether there is, in fact, that's why we refer to it as potential conflict of interest, whether there is, in fact, conflict of interest. There may not be, in which event then Advocate Hali can consider to provide that legal counsel.
Okay. I'll ask again. Does it have to do anything to do with the funding of Advocate Batoi for her personal legal advice or not? Or is it not related at all?
Well, it's related to some extent and not related in others.
Much as I know you have not as yet put pen to paper, but I think it will help us just to understand as to whether information that you will be bringing to us as the panel when that application is launched, whether that information will be information that has already been shared with the Solicitor General and the Minister when the initial application and appeal were done, or is it information that is totally new? And let me inform you as to why I'm asking this. I wouldn't want us to get involved in a toing and froing with the Minister and the State Attorney and so forth. I just want to understand that. Is it something that is looking to also paving the way in the direction? Or is it something that has already been shared and we are now being brought into a better light of what is already known by the State Attorney, the Department of Justice? Thank you.
Well, what I can say is that we as evidence leaders, are not privy to that information. We don't have that information. Our attorney is Mr. Sibele Meza, who is a different attorney from the attorney that briefs the NPA legal team. I think that information may well have been in their possession, but it's not in possession of our attorney, Mr. Sibele Meza. So we don't have information in that regard.
Advocate Skosana, that information I would have thought that during the discussions as teams now, when you make preparation or formulate intentions on what other avenue to pursue or not to pursue, you would have engaged even in the discussion. I think the chairperson did ask about whether you are privy to the information or not, and you did say that you were not privy to the information. There was a long break in between. And as you were sitting there as teams, either individually or collectively, certain thoughts came to mind about how to approach this. Did it not occur to you to try and get information so that we know that when we adjourn here, we are likely to be facing completely new information from the information that the department does have already, or whether it will be amplified information that has already been presented before the Department of Justice. Did you try to establish as to that case? Because remember that you argued for some time about this issue, about the interest of Advocate Batohi and so forth, and how the application failed at initial level and up to appeals level. But then you don't know what had been said. Did it not perhaps cross your mind to try and source that information from even Advocate Sibele Meja?
Well, all I know is that Advocate Sibele Meja does not have. I tried to check that, and I established that it doesn't have that information. And the attorney for the NPA legal team is not here, and so far we could not get hold of him. I think one has to also consider that information might also be privileged information that cannot just be acquired as easy as that. Information, I guess you're asking me about in relation to what was the appeal to the minister and what was asked to the Solicitor General.
Yes, you do not know for sure whether the information is privileged or not. You say it may be privileged information. You have not established as to whether the information is privileged or not. Am I correct?
Yes.
You have not established.
Yeah.
So it may or it may not be privileged.
Yes.
Thank you.
As regards the two issues that you raised, the potential conflict of interest, you will seek a specific relief, I suppose, in relation to each one of them. Possible conflict of interest in your application because it's an issue. The second one, challenges as regards the witnesses, you will seek a specific relief in your notice of motion. As regards the first, if your information, I'm just thinking aloud, if the information you are going to establish is going to raise new facts that were not brought before the minister or even before the Solicitor General, are we the proper forum to consider whatever relief you'll be seeking before us? If totally new information which ordinarily ought to have been brought to the attention of the minister but was not, and it emerges now, are we the right forum, given that the decision in relation to the core issue is an executive, or rather entails an executive decision? Elaborate, Counsel. Because ultimately, you'll ask us to grant you some form of an order or a direction. But if the information you are going to gather appears to be an information that ought to have been presented to the minister when making a decision, are we the right forum to even be given that information to make what decision, if the decision falls within the prerogative of the executive?
Thank you, Madam Chair.
Oh, I beg your pardon. I will repeat myself very briefly. I beg your pardon, gentlemen. My question is, yes, Counsel. I'm trying to think aloud because you do not want to anticipate an application in respect of which an ineffective relief is going to be sought, whereupon we don't even have a power to grant that kind of a relief. So the long and short of this question is, if the information that is not before you, that you are going to establish, is the information that ought to have been presented to the Solicitor General in the first place, secondly to the Minister on appeal, is found, will we be the right forum to even consider that information, because the decision is that of an executive, the Minister herself?
Thank you, Madam Chair. I think the application that we are bringing is essentially to ask for an opportunity for that question to be considered, not for the panel to consider that information as such, which was brought before the Minister and so on. At this stage, I think the application is to obtain permission from the panel to adjourn the proceedings until Monday, so that that issue can be resolved. And we think whether the information is already before the Minister or was not placed before the Minister will appear. One should remember that also the question of her getting legal counsel may get to a point where she has to obtain it privately, in other words, using her own, from her own pocket or from her own funds. We are saying, as evidence leaders, that opportunity that we are requesting should include that, considering all the questions, and when we return, it will be that she has obtained that legal advisor, whether from a private legal practitioner or from one that is funded by the state.
No, my question is different. My question is, pardon again, whatever you're going to establish counsel, you don't have information at the moment. But we know one of the issues relate to the potential conflict of interest, as you say, which impacts on the very request that was initially made to the Solicitor General and the Minister. Am I correct?
Issues were before the Solicitor and the Minister, yes.
No. My point is, and I'll repeat myself, the very issue that you have raised, the potential conflict of interest, impacts on the issue relating to Advocate Batoi's request to the Minister, ultimately.
Yes, Madam.
Is that correct?
It is correct, yes.
It is correct. Now, but the point I was raising with you, if it is correct, and this very information you are going to establish in due course was not brought before the Minister, are we the right forum even to know anything about that information in the first place? Because we don't have such a power which vests in the Minister to decide whether yes or no she could be afforded a legal representative. I'm looking at the question of relief, basically, that you can make an application, but when you make an application based on the facts that you are going to establish, if those facts are new facts and were not brought before the Minister, shouldn't you go back to the Minister and say, here are new facts that we didn't present to you, which may convince you as you exercise your executive decision to enable Advocate Batoyi to be legally represented at the personal level. Basically, this is what I'm saying. The panel doesn't have, you are not seized with such a power. Even if you come up with new information, to what extent does that information impact on the ministerial executive decision making?
Well, to answer the question, I think the panel doesn't need that power. And the panel is not asked to exercise that authority to decide whether Advocate Batoyi should be funded or not. The minister has already decided, as I understand it, the minister has already decided that she already has a legal team which is funded by the state, that's what the minister has decided. Now, the opportunity that we ask for is for the determination of whether there is a conflict of interest for that legal counsel to be provided by this legal team, the NPA legal team. And it may be that there is no conflict of interest. Then the NPA legal team will complete its task and grant and provide that legal counsel. If there is a conflict of interest, then the issue will have to be then resolved further, which I have already indicated may require that she now must obtain advice from a private legal firm.
So if I understand you correctly, and correct me if I'm wrong, what you want us, you seek to present to us is submissions or evidence to prove that there is a conflict. Do I understand you correctly, Counsel?
I'm not sure if I understand you, Madam Chair, yes.
The application that you The application you seek to launch deals in the first place with the potential conflict of interest. Now, if it is established from the facts that you are going to gather that there is indeed a conflict of interest, a matter which probably was not brought to the attention of the minister, shouldn't the matter then be taken to the minister, who has a decision, who has the power to make the decision regarding Advocate Batoyi's legal representation?
Well, Madam Chair, to decide whether, I'm not sure if the minister is to decide whether there's a conflict of interest or not.
No. If you present new evidence to her,
Yeah.
where in your letter or your memo you say to the minister, Minister, that which was presented to do previously, following on what information are going to be given, did not encompass this information that shows or reveals a potential conflict of interest. We are therefore urging you to consider this new information that then impacts on your earlier decision when you reflect on the new evidence that proves a potential conflict of interest. Do you understand what I'm saying?
Yes. Yeah.
Therefore, if that can be the case, why is it that it is us who must make a decision on the conflict of interest? Because it's just a factual matter. It's either you establish a conflict and then you go back to the minister, and the minister decide on whether to reflect on her earlier decision. And that's to start with the state attorney, Solicitor General. He may be persuaded. Then he can say to the minister, yes, I think Advocate Batoi deserves a legal team to represent her. The minister may also agree. My point is, why should such an application be brought to us?
Well, Madam Chair, let me start off by saying that may well be so, that an application may be brought before the Minister or the Solicitor General to say there are additional facts which establish a conflict of interest and therefore reconsider this application. But before we get to that point, first, we need to establish, or it must be established, that there is in fact a conflict of interest. Now, we haven't, in our submission, we haven't passed that point. We are asking for an opportunity to establish that, and that can only be established during the period that we are asking an adjournment for, whether there is a conflict of interest. And only after that can we go back to the minister, if that's the decision to be made, to say there are additional facts which establish that there's a conflict of interest in the team that you have directed must give advice.
Yes, I now understand. That's why we went this route of asking you questions, because you started at the application and we're talking about time frames as to when you're going to launch the application, when they are going to answer, when you're going to reply, when the written submissions are going to be filed. And we're talking in that context of you saying you seek an indulgence for a matter to be postponed so that you can make an application. And that's why these questions arise, Advocate Nkosana. But if you are saying now, it is not an indulgence to apply, but an indulgence to go and ascertain whether there is any information that may prove or disprove a potential conflict of interest with a view to approach the minister, is a different matter. Am I right?
Yes.
But if the intention is to gather information to prove or disprove conflict of interest, why would you need 7 days to do that exercise? If I understand you correctly, to say you want the inquiry to pause until Monday next week. And I'm asking this question on the background that we are pressed for time. And we've had to write a letter to request an extension and give reasons for our request. But then we start on the very first day, we're talking about pausing for 7 days. Isn't that counterproductive?
Yeah, I understand, Madam Malloy, SC, from where you come from, but I think, I said earlier on we will reveal this in more detail, but perhaps in the interest, and I understand the time frames and the time constraints, we must understand also the changes that are happening within the office of the NDPP. And I think that actually in a matter of a week, I think there will be a new NDPP. One should remember that the decisions to be made on behalf of the NPA would normally involve the NDPP. I don't know if you, I hope we all follow with these many acronyms, but the decision have to be made by the NDPP. Now, the new NDPP will come in.
Which decision are you talking about now?
The decisions that
I
may...
beg your pardon. You say decision has to be made by the new NDPP. Which decision?
Well, when we speak about when we speak about the potential conflict of interest, we're speaking about the potential conflict between the NPA as an institution and Advocate Bato, who is currently the NDPP. So, and as an NDPP, he also makes decisions on behalf of the NPA. And we all know that in a matter of a few days, there will be a new person in that post. So
the postponement for a week will enable the new NDPP then to be seized with the matter, basically, because Advocate Batoi will not be there anymore by beginning of February, which is about next week.
Yes. Yeah, I think I've said much. The Advocate Batoi cannot be involved at this stage in that decision, which may have a conflict with her personal interest in the office of the NDPP. And at the same time, she is making decisions as the sitting NDPP on behalf of the NPA. So it's convoluted, but what we are trying to resolve are all those issues, and which we are just disclosing those in order to enlighten the panel on the issues that we have to deal with and that we're requiring an opportunity to resolve. That is not, we are mindful of the time that we have as an inquiry, but at the same time, those are serious issues that actually warrant proper consideration and may warrant the granting of this postponement. As we say, I'm merely elaborating and elucidating without paper at the moment. We will provide proper affidavit in that respect and also submissions.
It's a long answer to my simple question, Council. I was asking you, the postponement would enable the new NDPP to be seized with the matter. As you said, I mean, if you postpone for a week, that's the end of the period of Advocate Batoi. Then she cannot decide. Therefore, the new NDPP then will be seized with whatever decision-making power, including this very issue. Correct?
Yes, Madam Chair. Just that I elaborated, but yes, the answer is yes.
In fact, as you have said, and I hope I understood you correctly, we are not adjourning that you apply. If I understood your submissions, you are not going to apply. You are going to consider whether there is any evidence, new evidence, if I may say, concerning the potential conflict of interest that was not brought to the attention of the minister. Am I getting it right?
I'm not sure if it's correct,
yes,
Madam Chair.
You see, all these things that discuss revolves around the issue of whether Advocate Batoi should be afforded legal representation, isn't it?
Yes.
So if the minister could have been given all the information that you're going to establish, maybe which was not before her, it means she must then be approached and say, reconsider your decision in light of this new information. Am I right in my understanding?
Yes, Madam Chair, I think partly because that decision would be to say, we're bringing this additional information, which was not before the minister, to say, now, grant permission that she be funded to employ another team other than the NPA legal team. Yet, at the same time, we are saying we still need to establish whether there is a conflict of interest. Otherwise, if there isn't, then the NPA legal team can continue to grant that advice.
Yes, that's what I'm saying. Yes. That's what I'm saying. I just want to ascertain whether you are going to launch an application, an interlocutory application, or whether you need the time, a week, to go and consider all these things that you are raising. And if you find this information, then where to go to?
Well, Madam Chair, if we are able to secure that time, that opportunity, without bringing the application, a formal application, I think we'll all and subject to what Advocate Nkabinde may say, then we'll all be relieved from bringing that application and asking the panel to make a ruling on it. But Madam Chair, you have correctly, I think you've capped it so nicely and correctly that those are all the issues that, as evidence leaders, have taken into account and which we thought we need to put it on affidavit formally in order to support this request for adjournment.
Yes, you see, Council, unfortunately, ordinarily, when you seek indulgence, a postponement, you apply. The reason why we ask you questions because you have not filed a proper application for a postponement for a week. And we need to understand why you are entitled to be granted that kind of a request. Because a postponement is not there for the taking. You have to explain to us, given the circumstances that we have elaborated on, the time frames and the time expended already, why is it that you should be given this, the request that you seek? Because we don't have anything in writing. So we have to ask you questions to determine whether indeed we can grant you the indulgence that you are seeking. So we are not just asking questions for the sake of asking. We want to understand where you are going to and what you seek to achieve.
Thank you, Madam Chair. I think I understand, and I have no difficulty in being asked as many questions as possible. I think I've been in that situation before, if not worse in the past. So I think I understand perfectly. I have no difficulty being asked as many questions.
I am tempted to say, Council, lastly, before my sister asks, if we do not proceed with this matter, or as we are minded to do, we may grant you the indulgence. But the indulgence will be coming at the instance of the evidence-leading team, which will cause a delay. So the delay will be at your door as evidence leaders. Evidence leaders comprised of a team of 4 advocates. And we find ourselves where we are today. So I just want to place that on record, that the delay should not be placed at the door of the panel because we are all ready to proceed. And we are even trying to look at other avenues. Whilst the issue relating to Advocate Batohi is being attended to, can't we even try, as evidence leaders, to look at the other possibilities of proceeding with other witnesses, the names of whom we have placed on the record? But we are engaging with one another, which something that is actually saying to us, to me at least, we are delaying with this process. I don't sit very comfortably with that kind of a position because time is not on our side. I'll repeat it again and again. We ought to have done better as an inquiry, as evidence-leading team, especially because you are 4 advocates. You have consulted with witnesses, and we're trying to really help you. Let's look at these avenues. Let's consider this. So you must also be seen to be helping us to make progress and not to delay the matter any further.
Thank you. Advocate Sosana, we engage you out of necessity. We fully appreciate that you sell time.
I understand,
Yes.
madam.
Yeah. Right, maybe let me just take off from where the chairperson has left the question, then I'll go to the next one. I would have preferred to do it the other way around, but that's fine. Now, my understanding of your statement when you are asking for a postponement, you say, is that what you are seeking to obtain is a determination whether there is a conflict of interest or not. Now, thus far it would appear that it would be 2 parties involved. It would be the evidence leader advancing whatever argument that has been brought to its attention, and then it would be Advocate Chauke's team also advancing whatever argument it may be. Now, what I first want to know is which side of this question are you? Is it about obtaining a determination that there is in fact conflict, and the other one is opposing that and wanting the panel to find that there is no conflict? Can you just indicate to this panel as to which side? Are you the applicant, or the evidence leaders team is the team that seeks to get a confirmation that indeed there's a conflict of interest, or is it a team that seeks to obtain a finding that says there's no conflict?
Well, the way I understand it is that we are on neither side. We are not on. Well, if there's a conflict, there is a conflict, and the conflict will be between the NPA and Advocate Batohi. And if there is, then that means the legal team cannot advise her.
Thank you. You know, this question, it's a question that I'll say is just been changing colors and sizes and what have you, but it's the same question about the relief sought. Who is seeking which determination? And when you say, well, we are on neither side, what are you doing? Are you going to file, in the event that you come to a conclusion that there has to be an application, are you going to file an affidavit that says we shall abide by the decision? We not seeking any determination as evidence leaders now, because I think I got it wrong. As I was listening to you when you said, what we seek is to obtain is a determination whether there is a conflict of interest or not. Now, from that statement, what came to my mind is that here it means there'll be no less than 2 parties. One contesting for a determination that there is a conflict, and the other contesting against the determination. But I may have been presumptuous and assumed that that would be the case. And it would help us, you as the evidence leader, to just clarify that issue as to, you have made it clear that you are neither for nor against. So what role will you be playing as the legal representative leading the evidence leaders team in this respect?
Yeah, I think, Madam Ramakaka, we are correct that we are not on either side. All we are saying, we're asking that an opportunity be granted for that to happen. The legal team, the NPA legal team, will establish themselves whether there is a conflict of interest. If there is, then they cannot provide the advice. If there isn't, then they'll provide the advice, and the advice, we don't know what advice they will give. It will either, no, don't go back, don't, or it will say, and then we can then, from there, that Advocate Batoi, we are certain now she is not going to return to continue her testimony. And then in that event, what do the evidence leaders do?
Is there a role that you foresee playing? And when I say you, I'm talking about you as a collective. Is there a role that you foresee yourselves playing in this issue of a determination whether there is a conflict or not? And if there is a role that you see yourselves playing, what is that role? Thank you.
Yeah, at this stage, I don't think we really have a role there. The issue is between the NPA and Advocate Batoi as the current NTPP. So all we are waiting for will be an answer. Yes, there is a conflict, yes, or there isn't. And we think with all the information we have, the reasonable time will be up to Monday. And I've indicated that also there would have been a change of hands in the office.
Thank you. Let me then get off that subject. It has been canvassed. I can't say adequately. There may be a need to canvass it further. The question that now I want to go back to is the question of a list of witnesses. Remember, there are two grounds for the application. It's the witnesses' challenges and it's the potential conflict. Now, I'm addressing the issue of the list of witnesses, right?
Yes, so sorry for interrupting you, madam. I just, that question, I think that's the one where you were saying you're going to grant me an opportunity to confer with my team. Unless it's not related to that, just wanted to.
Yes, I remember that I think it was actually the chair who then indicated that, you may get it, you may have to obtain instructions. And let me then be disciplined and restrain myself from asking you the question that I wanted to ask. I stop here for now. Thank you.
I'm going to make a follow-up on what my sister have asked you. You said you don't see, for now, you don't see yourself, the evidence leaders, playing a role in the issue of conflict of interest. This is between the NPA and Advocate Batoi. Now, are you requesting this period of until Monday on behalf of the NPA and Advocate Batoi? Or you made your own judgment to say we will need this period, or they will need this period to deal with the issue?
Well, as evidence leaders, it has been repeatedly said that our duty is to bring evidence before this inquiry. And we have been doing that. Advocate Batoyi has been called as a witness by the evidence leaders. And in the process, there were these challenges or difficulties. So we're trying to merely resolve that. And we thought in our own right as evidence leaders, we could bring that application in order to ensure that things proceed in a proper manner. And she is given that opportunity. And we think a reasonable time would be up to Monday, and in view of what I've mentioned, what is happening at the moment.
So as a follow-up, it is the evidence leaders who determined this period. And while keeping in mind that you are not going to play any role in the resolution of the whole issue. And you are right. You, as evidence leaders, you are the ones who are driving this process, who must see to it that it comes to an end. And after having raised issues about timeframes and everything, and after you having considered that you are not going to take part or to play a role in this issue, do you still insist that you need 7 days to resolve the issue of conflict that is between Advocate Batohi and the NPA? And I will add further, because you now brought in the issue that in next week, a new head of office will be taking over. Now, we're breaking until Monday. Come Monday, a new head of office is taking over. And I'm wondering if the new head of office would have considered everything and made themselves au fait with this whole inquiry and its issues by Monday, or for the head of office to take a decision whether there is further funding for Advocate Batohi, or Advocate Batohi must get her own private legal funding. It seems like we are trying to kick the can down the line. I don't see the end of this, because come Monday, there will be another issue. There is a new head of office who needs to apply their mind in order to take a decision. I don't expect a person to jump into the office on Monday and decide, okay, no, we are not funding, or no, we are funding. They'll have to weigh the options and to consider that there is an NPA team, and where is the conflict, and what is happening, what has been happening during the initial consultation stages, and all those. And also maybe want to go through the whole record to acclimatize themselves with what is happening. So is this ever going to come to an end? And also, what informed you to request for 7 days? I don't even want to imagine what will happen beyond the 7 days come the new head of office next week. Why? What? Because Advocate Batohi started the process, and rightfully so. She was empowered. She is empowered, actually, not in the past tense. She is still empowered by a statute to deal with this process. So why should it be that we want to postpone, we want to pause until a new head of office comes in, and then deal with the issues thereafter, when we have a process that has started, lawfully so and legally so? I don't want to believe that we are trying to kick the can down the line, down the road. Thank you.
Well, certainly not from our side as evidence leaders. We're not trying to kick the can down the road. one must consider that when you say there is a conflict between the NPA and Advocate Batohi, who do you ask that question? On behalf of the NPA, you have Advocate Batohi, because there has to be a person. NPA is an institution. Now, obviously, you cannot ask that question to Advocate Batohi to give you an answer on behalf of the NPA. And that's in that context that we are saying it is important, and perhaps it may help us to resolve the issue if the new person takes over the office and makes the decision on behalf of the NPA. And may I add also that we have been doing some of the things, and some of the submissions also have been discussed with the NPA legal team, who at this stage, of course, they have no audience in this inquiry. I don't know if the panel still intends to grant them an opportunity to address them, but we also had some discussion with the NPA legal team.
As a follow-up, Chair, Advocate Skhosana, shouldn't right from the beginning, your submission, shouldn't it have said we want to pause and wait until the new head of office comes in order for the head of office to take a decision? Because we've heard that you want to bring an application to this panel to make a determination. The next thing, if there is new evidence, it needs to go to the minister. And then the third thing, you are not going to play any role. You don't see yourself playing a role. But all I'm saying is, it seems like the crux of this request for a postponement is to allow the new head of office to come in and deal with this issue. Am I correct? Correct me if I'm wrong.
Well, it's an important factor, but it's not the only factor. We have, and we intended to put that on paper. There are several reasons which I've divided into two categories, but it's not the only point. It is an important point.
The answers are giving rise to further questions, Advocate Skhosana. I thought that a process has started in respect of which Advocate Batohi approached the Solicitor General and then the Minister. I don't see why the new NDPP comes into the picture. If the information to be established as regards the potential conflict of interest is found, the new NDPP doesn't come into the picture. He doesn't have powers to make any decision whether Advocate Batohi should be given money or not. The matter goes back the same route where it started, back to the Solicitor General with the new evidence, and then the Minister on appeal. So I don't think we should complicate issues here and bring a new NDPP into the picture, because that's going to create a whole problems for us. And I'm just saying there's a matter of guidance. My understanding is that this decision taken by the Solicitor General and then subsequently the Minister, which does not favor Advocate Batohi, may have to be revisited because of this alleged potential conflict of interest. And if indeed, as you receive the information, you find that there is a conflict of interest, then you present it to the Minister, first to the Solicitor General, who may just resolve this issue and say, yes, upon consideration of this new issue, we decide otherwise. If they don't, at the State Attorney, you then approach the Minister with this new information. I don't see how the new NDPP comes into the picture. Where do we start? Where do we end with this whole thing? So I'm raising it so that we don't lose sight of the fact that a process has started, and we may have to go back to that same process without necessarily involving the new NDPP, because the decision is that of the Solicitor General and the Minister, as I understand it. So I thought that you need this postponement to consider that. You said that you are not making an application. So if you need time to go and make that determination, shouldn't 2 days be enough for you to ascertain that the Solicitor General is here? Then you can then decide what procedural steps as regard the decision you seek finally are going to be. Do you really need a whole week to do that? And that's the point my sister was raising. Why do we need a week? Because if you had applied, we will be having facts in front of us. That's why we are asking this question. Why do you need a week? A full week, for that matter.
Well, Madam Chair, is because of the reasons and the other grounds that we put forward, and we seek to put forward in that application. We have mentioned, and I said it's two categories. It's about the issue of the conflict or potential conflict of interest. There's also the issue of witnesses, which we also seek an opportunity to explain by way of affidavit. And the question that has been raised about the other set of witnesses relating to the Mdluli case, I will need an opportunity there to confer before I respond to that.
Yes, the question of witnesses, we had indicated that we'll give you time to confer with your colleagues, because if we are agreed that the process to follow, if you're mandated to grant you the 7 days, or maybe even less than 7 days, is to make a determination on evidence as regard to potential conflict of interest. Then the other issue as regard the witnesses, we said, if it is possible then to proceed with the Mdluli matter, then consult with or confer with your colleagues and determine whether the witnesses who have been lined up can be called. Then we can proceed. Whilst we are dealing with the Katomena issue, the potential conflict, the witnesses that are giving you challenges. So I suppose we go back where we were, that we will afford you an opportunity to then confer with your colleagues to discuss that second matter. Can't we proceed with the Mdluli matter? Those witnesses would have been lined up. You'll have a time, I beg your pardon, I'm talking?
So, I beg your pardon, Madam Chair, just a paper that I wanted to understand.
You'll have regard to your paper. I'm saying, I'm just trying to line up the process. If you are agreed, then we can pause, and then you properly consult with your colleagues as regard the second issue, and so far as the Mdluli matter is concerned. Maybe we can start whilst you are dealing with the other issues.
We will respond to that. And Madam Chair, while you're on it, the note I've received is a request that Advocate Batoi be excused for the day. That's what disturbed me a few minutes ago.
Thank you, Chair.
Yeah, before you proceed, Advocate Batoi has just asked that she be excused. I think we can allow that. We are engaging with one another here, so Advocate Batoi can be excused. Is it correct?
Yes, but we have to agree about who will inform her about the next date. Because now she cannot.
Yes. Yes. My sister raises a point. someone will have to tell her, if you decide that we'll postpone this matter for a week or for less than a week, someone has to give her a date. Suppose yourself, as the evidence leader, you brought her here. I think it would be proper to hear from you. So I don't foresee any difficulties with you conveying to Advocate Batoi about our final decision in relation to the postponement.
Yes, we'll do so, Madam Chair.
In that event, Advocate Batoi, we have received your request. You are excused for now. Thank you.
Advocate Skhosana, I'm asking for a question. I'm asking a question which is capable of being asked in or answered in clear and unequivocal terms. And if it means you get information from your instructing attorney, you can do so. And understand one thing, I will not try to even tempt you or provoke you to come up with the information that was placed before the minister. I'm not looking for the substance of the information when the application was done. All I am asking for is for you, if by now you still do not know, for you to find out from your instructing attorney as to whether the question of potential conflict interest ever served before the SG, I want to call it in full. That SG, what do you call? Solicitor General. Thank you, senior citizens on the bench. Solicitor General, or even the minister. Just to establish that from him as your attorney of record. So you see, you understand when I say it's simple and capable of a clear and unequivocal answer. Because it's either it's going to be yes, it had been placed, or no, it wasn't placed. The issue of potential conflict of interest when Advocate Batoi applied for funding from the department.
Yes, I will ascertain that.
Thank you, Advocate. Are you done, madam?
Yes, I'm done. Thank you, Chair.
Thank you. Thank you, Skhosana. Advocate Nkabinde.
Madam Chair, we will oppose the application for postponement, but we do not think that we can oppose the fact that they want to apply. So we think they should be given a chance to apply, but we will oppose it on the merits. There is a lot to be said, but I think it should wait until we see the content of the application. If they want to bring the application for consideration this week, we would propose that they try and launch it by tomorrow at 5 p.m. and give us a chance to answer it by Wednesday at 5 p.m. It can be set down for argument on Thursday at 9, and they can file a reply at the same time as the matter is argued. And that will give the panel the Friday to make a determination on whether the postponement is granted or not. Now, arguably, Madam Chair, it can be asked, well, what's the point of this exercise, because they only want an adjournment until Monday. But we think it's nevertheless important to put it on oath what the problem is, why the matter cannot proceed, bearing in mind the public interest that underpins these proceedings. It's the first time we've heard that there are problems with witnesses, but I also don't want to speak about that because my learned friend has not explained the nature of those problems, and maybe he is waiting until someone qualified goes under oath on those. But we will see what they say in those. The question about Advocate Batohi, I think I just want to say maybe two things. One is that we must not forget that she has walked out of the proceedings without the consent of the panel. The panel should not create the impression that you can reward the delinquent behavior of a witness who walks out and then makes an application while outside. She walked out on the 15th of December. Today she was present, but even today she elected not to give evidence. In both of those instances, those were unilateral decisions which did not have the permission of the panel. So although we are debating the question of her access to legal representation, the context must not be forgotten that we are dealing with a witness who's taken the law into her own hands and disregarded the authority of the panel. That's the first contextual matter that is really critical there. The second issue around the unilateral action of Advocate Batohi is the impact that it has on my client. My client is on suspension. He believes that his suspension is wrongful because he believes that the charges are without any foundation. Whether he's right or not, he is entitled to a speedy determination of that question. The election of Advocate Batohi to unilaterally abscond from the proceedings has already taken a month and a week from these proceedings. So that is why we will be opposing the request for the adjournment. If our learned friends are ready on Monday to call the next witness, we would of course be pleased and we will be ready to cross-examine them as soon as possible. But I understand that that question also depends on the challenges they will be outlining on paper. And that's why it's premature to make commentary on that issue. So in summary, Madam Chair, we are not standing on the way. We will play along and cooperate, and we've got a proposal around the timetable. Thank you.
Yes, thank you, Advocate Nkabinde. But you have to remember that Advocate Skosana seemed to have changed tack. Initially, he sought an adjournment so that they could apply a substantive application. Subsequently, he says what they need is time to go and consult and make a determination whether there is a conflict. Meaning, he's doing away with an application, and once they find that there's a conflict, then they will take the next step. That's why the engagement as to then who is the right decision maker if they find that there is a conflict. What is the impact of that finding or determination as they will find when they assess their facts or evidence? And I said to him, this is not a forum to make a decision eventually. It's an executive decision. And I would like to hear from you. The process kick-started with the Solicitor General. It ended with the Minister on Appeal. Now, if they have to start the process de novo on the basis that new evidence has surfaced which impacts on that very decision. They must go the same route. And the point we make now is the same route, is that determination, establishing those facts, require a week. At the moment, tentatively, we think a week is too long. They are not bringing an application, if my understanding is correct. Because if they bring an application, the question is, what relief? And I'll be very much interested on the relief they seek from us. If you don't have the power to decide on whether Advocate Batohi should be given funding or a separate legal representative or not. It's an executive decision, not the decision of the panel. That's why they have to go back the same route. But do they need a week to do that? That's the question.
Madam Chair, the answer is no, they don't need a week to do that. They need a day. There are substantive answers to it. Advocate Batohi is not entitled to state funding. State funding is discretionary. She has no right to state funding. The panel has no power to order the minister to give Advocate Batohi her own funding. Advocate Batohi is also not entitled to consult with an advocate in the middle of her cross-examination. That is in violation of the rules of the bar. So the relief that she wants is against the law of this country. But it's premature to engage in that argument until we see the application that will be brought. The second...
No application? You won't see any application.
Unless I misunderstood my learned friend, I thought they will still bring an application because he says it's two-pronged. The first prong is the conflict issue. The second prong is the witness readiness issue. So an application is coming, as I understand. But insofar as the first prong to the issue, she has absolutely no right to any of the things she's asking for. Now, you cannot ask a postponement of an inquiry in order to achieve things you are not entitled to by law. So, but they still want an adjournment so that they can work through the difficulties they are experiencing with witnesses, something I sympathize with until I see what exactly the challenges are. But at the moment, I don't know, and maybe my learned friend also doesn't know, and we will see what they say. So it's only in that context that I say a timetable is still indicated, because we may have to deal with the problem that if you were to say to them, now, Madam Chair, it's 2:15, call your next witness, they won't be able to call anyone. And so that's why they want a postponement in order to sort out that problem, which I understand, and that's the timetable I was really addressing myself towards. If he doesn't want to bring an application in relation to the first issue, that's fine, but I understand him to still persist with it if I'm fair to his submission.
Yes, thank you. And in fairness to the evidence-leading team, we have given them a leeway to confer as regards the issue of witnesses, which would ordinarily have necessitated that application, as you say. So we will have to await their conference. We'll adjourn and enable them to talk, to establish whether we can start with any of the witnesses in relation to the Mdluli matter, at least, so that you don't waste time. Whilst the issue regarding the potential conflict of interest is being considered by them without bringing an application. And of course, that issue, if it is so well established, you then land on the desk of the Solicitor General and then the Minister. It has got nothing to do with this inquiry. And if the Minister is persuaded, then she will decide as persuaded. Or if the Solicitor General decides favorably, he will decide. These are public funds. We don't get involved there. If the Minister and the Solicitor General has money to engage further counsel, further set of advocate because of the alleged conflict of interest. That's their decision. But what bears heavily on us is the delay. We should be able to proceed, at least with some of the witnesses. Do you agree?
We agree entirely. There's something to be said about the delay. It's important to get moving with the inquiry. Advocate Chauke is also entitled to know the outcome. But this is a case also of immense public importance. I don't know of any inquiry like this where the question of a prosecutor not prosecuting despite the evidence and prosecuting without evidence has ever been tested in this country. And the accusation is made by a person no less than the NDPP. And it is made against a DPP. So this is a matter of immense importance. And the facts that have been uncovered so far are also troubling facts. So the public is also entitled to an outcome. I always think, Madam Chair, since the evidence in this case of the mother of KwaZindlovu, she is entitled to know what is the truth about the killing of her son. And the delays are not helping her to get resolution to what happened to her son.
Without elaborating much on the issue of public interest, it's also a matter of legality when there's no finality to issues of such national importance. Put aside the issues of budget. A lot of money is expended on this inquiry, and it has to be brought to an end as soon as possible. So there's just so much at stake. It cannot just be issues of postponing for the sake of postponing. That's why we're engaging with council, to understand why is it that this matter has to be postponed further. It was postponed last year. We lost more than a month. Now we're going to lose a week. That's why we're engaging with council to understand the basis for postponing for a week. If we can indulge them, because I think in fairness to them, they need to confer with the Solicitor General, Advocate Andrew Chauke. I've seen your correspondence. They must consult with you, sir. But a week is too much. We need to finalize this matter, at least make some progress. So I think, Advocate Andrew Chauke, we will take an adjournment, unless my sisters would like to ask something. We will adjourn for, how long would we need, Advocate Skosana? What do you, 15 minutes? 15 minutes or so? And you will let us know once you have discussed. You know what our position is. I think we have repeated ourselves again and again. And please, when you come back to us, assist us, because we don't see ourselves going home to wait for next Monday with an application just for you to go and talk. So Advocate Chauke, thank you. I think in fairness, we will, after my sister has asked, and if there's any further question from my sister on the left, we will then adjourn for 15 minutes to enable Advocate Skosana and team to talk. And when you are ready, we will come back. You will then have to indicate whether, in the context of the issues of Mdluli matter, whether we can start either on Wednesday to notify the witness who will come, and we continue. So don't let us know.
I just wanted to ask you to consider this. Remember, we adjourned on the 15th of December, and on the day of the adjournment, we knew that Advocate Batohi is going to request her own personal representation. So that's one thing that you need to consider, and also consider when did the minister take the final decision and what happened thereafter. And also the fact that you had a framework, you had an inclination of the witnesses that you're going to call. And I don't want to believe that they all dropped you on Friday, this past Friday. So while you are conferring, please try to give us as much information as you can so that we understand what happened. I don't think they had a meeting on Friday and decided, oh, the inquiry is sitting on Monday, we are all not going. So please take us along on this a month and a week that we've been waiting, and while time is ticking. What happened in the process, and what steps did you take to try and mitigate, to try and assist this inquiry to be finalized within the set time frames? Thank you. Thank you, Chair.
Yes. Hosanna, I see you're pressing. Yes.
No, I just wanted to confirm that we will do our best to bring that information.
Thank you, sir. Council will take an adjournment for 15 minutes until 3:15, until 3 o'clock. You will send our researcher to call us. Thank you. Good afternoon, everyone. Good afternoon, Council. Advocate Skosana.
Thank you, Madam Chair and the panel for giving us an opportunity to confer. Madam Chair, before addressing the issue, and I believe I'm going to be short on the issue of the witnesses, it has been indicated to me that Advocate Harley, SC, would like to address the panel as well, particularly on the issue of the conflict of interest, insofar as the resolution of that question may require up to a week, up to Monday next week. I will leave that to the panel, that issue. But on the question of witnesses, Madam Chair, the answer is simply that as evidence leaders, we had a plan. And firstly, the plan was that we were going to deal with the issue of the Katomena and the witnesses. And on that basis, I personally requested to be excused from this inquiry, to go and consult with some of those witnesses. And I consulted with one of them. One must remember that these witnesses are of high-ranking officials, advocates, most of them. One of them I consulted for not less than 12 hours. And thereafter, that was now before the adjournment on the 15th of December.
So, Council, the witness you consulted with, was it in relation to Katomena or the matter?
The Katomena, Madam Chair, yes. And our plan was that we wouldn't like to deal with witnesses haphazardly. Call a witnesses in relation to Katomena and then the next in relation to the Mdluli case. But then I consulted with that first witness, and thereafter, on the basis of what I had been told, prepared a statement, which was not a short statement, of at least 20 pages, and provided to the witness, who then informed me that it's going through the statement, and we're now in the thick of the festive season. And later on, I also consulted another witness who had been allocated to me to deal with that witness. Second witness, who we could not physically meet over the festive season, but I held a consultation over certain aspects with him, with the understanding that we'll continue with the consultation in the beginning of 2026. Now, the first witness that I consulted with, after a while, I think it was about over 2 weeks, returned to me to say is not happy with the statement, and she requires an opportunity to prepare her own statement. That being the case, and
she needed an opportunity to
prepare a statement of her own,
statement.
Yes, and provide it to me to be able to settle it, and then we could finalize our consultation. And also, one must remember that we needed to provide statements to the team of Advocate Chauke.
And these witnesses, as you said, are high-profile witnesses?
Yeah, witnesses, yeah. They are advocates in the NPP's office.
Yes.
Yes.
So she is an advocate. She could prepare her own statement.
She could prepare her own statement, and which days passed, and I made follow-ups as much as I could. Where is your statement? is not coming through, is not coming forth. That and I'm giving just a broad overview of what happened. That was now up to last week. It is only on Thursday, to our greatest surprise, that the witness informed me that she is not prepared anymore to testify. And she gave us the reasons for doing so. She gave us a statement, quite a long statement for us to go through, some report that she had previously prepared for the office of the NDPP. Now, that was now Thursday last week. And on Friday, I also received a WhatsApp message from the second witness, who informed me again that because of his commitments, in short, because of his commitments, or the commitments that he has made this year in his life, you know, the studies, and he counted a number of things, is no longer prepared to testify in this inquiry. And which we conveyed, I conveyed to the team. So, in essence, our plan, and these two witnesses, I must mention that in terms of our estimation, the first witness would have taken our estimation about 8 to 10 days. The second one, 6 to 7 days. And we had contemplated that in the event Advocate Batohi does not return, we would be able to cover that period. And the rest of the colleagues, during their testimony, the testimony of these witnesses, they would be going out, they would be excused, like just like it happened to me, to go out and consult with these other witnesses so that the proceedings are not interrupted. We can proceed with the case. I also want to mention that Advocate Mohlamunyane SC, on the other hand, was also consulting with a different witness who also would, according to our estimation, would take about 10 days to 15 days. That's our estimation of the testimony. And received a message from his attorneys that the witness will not be able to testify.
His attorneys, are you referring to Advocate Mohlamunyane? His attorneys.
Sorry, the attorneys of the witness, who has separate attorneys. So we were informed that they need to consult with this witness, prepare the witness, and in what they are doing, the witness will only be available to testify towards the end of February 2026, in this inquiry, because they want to make sure that they secure the rights of their client, who is the witness.
If I may ask, is that Major General Boyson? Because I saw a letter from an attorney which expressed sentiments to that effect. Is that the Attorney Kun? Is that the attorney?
Madam Chair, Madam Chair, you are right on the point, yes.
Well, that takes us to the third witness. You've spoken about two witnesses.
To
This
the
one
third witness,
is the
yeah.
third witness.
I am informed that the witnesses, and that would take about two more, well, I think three, in the Katomena one, who my colleagues, we allocated each other, one another. They had difficulty getting hold of the witnesses in the first place during the festive season, some of whom were not prepared to meet them during the festive season.
Are you speaking for or on behalf of Advocate Mchene, for instance? I remember at one stage last year, he asked that he be excused to go and consult. Are you speaking on his behalf as regards when you say my other colleagues?
I'm speaking on behalf of Advocate Mchene and Advocate what's his name? Sorry, Madam Chair. Yeah, I'm used to the first name.
First hear what the position is with regard to Advocate Mchene, because I remember he had to be excused last year to go and consult with the witness, and what has happened with regard to that consultation. I just want to establish whether the evidence leading team has prepared witnesses for us to proceed. And if there are challenges, precisely what are those challenges?
Yes. Madam Chair, maybe to also add or to clarify is that as far as the witnesses relating to the Mdluli case, must be honest that we had not consulted. And the plan of the evidence leaders was that that would take place once we see we are towards the end of the case relating to the Katomena. And would like to also emphasize that what has really disturbed us and put our plan off track is what happened last week, because with the two witnesses. Because had that not happened, we are sure that we would be able to proceed, even if in the light of this postponement that we're asking for with those two witnesses, and they would take time long enough for the other issues to be resolved that we are dealing with regarding Advocate Batohi.
But let's get to the specifics. How many witnesses did you list in the list were to testify in relation to the Katomena matter? Because you have spoken to two witnesses who collapsed that you had consulted with, and the third witness who is supposedly collapsing is Advocate Boyson. We have seen in the correspondence.
Yes.
There are other witnesses in your list as regards the Katomena matter. What is the position in relation to those witnesses? You mentioned that your colleagues have not been able to consult. In relation to which witnesses were they not able to consult? Pardon, yes, sir. I'm sorry. In relation to which witnesses have your colleagues not been able to consult?
Madam Chair.
In relation to the Katomena matter?
The Katomena matter, because we had resolved and planned that would deal with those witnesses and be able to conclude that. And the consultation in relation to the Mdluli case would take place when we see that we have covered the Katomena, and towards the end of it, of course, would ask for an excuse of some of the colleagues to go and consult so that there is no interruption. But
how many witnesses were allocated to each one of you?
I personally had how many? At least 3. Yeah, but I must indicate that for this period, I was focusing on the witnesses that I was going to call.
So you
And-
consulted only with 2 witnesses who have collapsed?
We have collapsed, yes.
The third
as
one?
Of last week. The third one I had not consulted with. I had not even had an opportunity to do so because my focus was on the 2 witnesses. And one would appreciate that the issues of and information on this matter is quite involved, and my focus was on them. I have not yet consulted with the 3rd witness.
Advocate Mchweni, how many witnesses?
2 in the case.
Thank you, Madam Chair. Chair, according to the record, to the allocation, it was 2 witnesses.
And what has happened with your role?
No, in fact, it's 3, Madam Chair. I apologize, it's 3. Yes.
How many have you consulted with? How many have you consulted with?
Chair, I've not been, I'm going to be honest, I've not consulted with either of them because the idea was that we would, once we resume, the idea was I would have been excused to consult with them so that we can prepare the statements. Their evidence is not long, so I anticipated that within a week or 2.
Please speak to the microphone.
I had not consulted with either of them at this stage because the idea was us we were still familiarizing ourselves because, like, for example, there's an officer here whose evidence is interlinked with both the Cato matter and the Mluli matter. And due to the voluminous nature of the papers, one had to start familiarizing themselves with myself with the Cato matter, then used the festive season to familiarize myself with the Mluli matter. Then the idea was, once the hearing resumes, I would then ask to be excused so that I can go and consult with them, prepare the statements. And the anticipation was that it would not have taken me more than 2 weeks to finalize their statements. So, hence, I had not consulted with them. But the idea was that I was not going to sit here throughout the evidence of Ms. Patoy or these other witnesses.
Last year, you asked to be excused to consult with some witness, if my recollection is correct.
Yes, at that stage, the idea was between Advocate Kosane and I, was that we would share the 2 witnesses, Advocate Noko and Mlojo. But because Chair refused that I should be excused, then hence Advocate Kosane had to also consult with Advocate Noko and Advocate Mlojo. But the idea was that we were going to share the 2 witnesses together.
If my understanding is correct, on the division of labor, not much has been achieved by the evidence-leading team. And I'm saying this with the greatest of respect, but look, we are now on the 4th month, or if I may say, the 3rd month or the 2nd month, and we are still talking in terms of we have not consulted with witnesses.
Chair, unfortunately, but what one can't lose sight of the fact is the stage at which we came into the matter.
I beg your pardon, sir?
I'm saying, in as much as that is correct, sight should not be lost of the stage at which we came into the matter. We came into the matter when the hearing had resumed, and we were expected to, amongst others, familiarize ourselves with the papers, also be here to assist the evidence leader during the leading of the evidence. So the only time that we had so that we can focus and delve into the papers was over the festive season, because the last 2 weeks, the 2 weeks that we came into the matter, we had to be here, and at the same time use the after hours to read through the papers.
Now, I'm sorry, of the 3 witnesses, who could be ready to start in due course? Have you started? Maybe it's a fair question. Have you started?
Chair, no, not yet, but I can start immediately. And depending on the availability, I can try and be ready within a week.
I'm not trying to dictate how you should run your side of the matter.
I appreciate that, Chair, but
But,
at the end of the day, I have a role to play here, and if that role means that I have to be dictated to, I would welcome the dictation.
I can't dictate to you. You are here to gather evidence and present it to us.
Yes, that's
We
what I'm
don't even
saying.
know what who are your witnesses are. You've just given us a list in December, and you expect that you would have gone out of your way to try to ripen this hearing.
I appreciate that, Chair, but hence I do not want to be seen to be giving excuses. But also, Chair, one has to appreciate that it was festive season. Some of these witnesses had their holidays planned. And one couldn't just give them a call over Christmas holidays and say, hi, can you avail yourself for a consultation? One had to respect that as well.
Yes.
Yes. So had it not been, but if it did not have a festive holidays in between, the criticism would be justified under the circumstances, Chair.
Are you saying the criticism is not justified?
Not necessarily, Madam I'm just saying that maybe, okay, of course, I'm lost for words.
It is not even a criticism. It's a fair statement
Yes.
from the bench.
Which I appreciate.
I think you must withdraw that.
I withdraw the statements and criticism, unreservedly so.
Yes, thank you. Yes, thank you, Ramchani. And the junior counsel, were you allocated witnesses to consult with?
Yes, Chair, I was allocated 2 witnesses in the Mduli case, and 2 weeks ago. And I also must say that because I came at a very late stage just before the adjournment, I had to go through the record and familiarize myself with it. And I used the December holidays to do just that. And because we are still going according to the plan that we had, I did not foresee that it would collapse completely within 2 days. So I have not consulted with them, but I'm going out to do that.
You see, I'm asking all these questions, counsel, to make sure that eventually, if we are to say a postponement is warranted, we know on what basis we are granting you the indulgence and for how long.
Yes, Chair.
Because as I mentioned to senior counsel earlier, as you know, postponement is not there for the taking. It's an indulgence.
Correct, Chair.
And we don't have an application in front of us that will inform us as to whether the request should be granted or not. And am I correct that the witnesses that have been allocated to you also relate to the Katomela case?
No, Chair, it's the Mduli case.
The Mduli matter.
Yes.
Have you started? You haven't started at all?
Consulting with the witnesses, no, I have not.
When do you plan to start that consultation?
I will have to contact the witnesses as soon as we adjourn, and then I'll just take it from there, Chair.
Thank you. My sister?
If I may ask, was there any particular reason why you decided to concentrate only on the Katomela witnesses without taking statements from the Mdluli witnesses, not with the aim of calling a witness in the Katomela and then calling a witness in the Mdluli matter and then confusing the record. But I'd like to know if there was any specific reason why you decided to treat them as 2 separate matters to a point that you want to finalize only, you want to consult these witnesses on first first before you go to the other witnesses.
I am not sure whether there's really any particular reason, but I may say that, look, having joined these proceedings also in the middle, I found the evidence being led already of Advocate Batohi, and looking at how things were, is that the focus was mainly on the Katomena. Of course, her evidence covered, to some extent, the Mdluli matter, but it seems to us, and when we discussed it, that it would be proper and logical to deal with that part of the case and complete it, and then focus on the other part of the case. I must mention also that with Advocate Koe was given those witnesses for Mdluli, particularly because we needed to give an opportunity to familiarize herself with the information and the facts of the matter. And that would have given an opportunity to do that if things were to happen in the normal way. But firstly is that we understand and we all didn't know what is going to happen now that Advocate Batohi took the decision in December. Number one. Number two, our plan was that we are going to fill that gap so that there's no interruption through these witnesses. That's why my absolute focus, and those witnesses would have, if they were prepared to testify, covered quite a great area of the case, evidence of the case. So we in all reasonableness that we had, we thought that would secure and avoid interrupting these proceedings if we were to secure these witnesses. And all indications from them, and I speak personally because I spoke to them, were that they were more than willing to testify. And they gave me some statement, and as I indicated, I consulted for many hours with one of them. And it was really a sudden and unexpected turn of event when they said they're no longer prepared to testify. To some extent, and I'm not saying perhaps to some extent we are to blame, but essentially what has happened is what we really could not reasonably anticipate or expect to happen, particularly in regard to these two witnesses.
It is, however, correct that when you were appointed, I think Advocate Skosana, Advocate Mchwene first before you, I think Advocate Mchwene was appointed before you, correct?
Yes.
And subsequently after you, the junior counsel was appointed. When you were appointed, at that time, Advocate Batohi's statement, or a statement under oath, was before you, as it was before us. And that statement encompasses both issues, the Katomena issues and the Mdluli matter, which in my view, and correct me if I'm incorrect, would have given you a start, all of you, those who are allocated to consult, at least to start with some witnesses, junior counsel, especially with relation to the Mdluli matter there. Because the statement was there, the affidavit was there. It is not like everything that surfaced during cross-examination was mentioned for the first time. There were other issues that she raised in her statement which would have enabled you to identify the relevant witnesses. So why is it that that was not done? Just to expedite the matter, I'm trying to understand. Fine, the 2 or 3 witnesses have collapsed, but for the rest, why is it that consultation was not done? I'm just thinking, Advocate Mutlamunyane was leading, and then you have the three of you sitting here, and then at one stage you asked to be excused, and I'm trying to think, to understand, why is it that whilst you were presented with Advocate Batoi's statement under oath, little seems to have been done. Very little, it appears. Over a period of a month, maybe I should say that, or closer to a month. And now we have to take a week's adjournment according to your request.
Yeah, well, as far as that is concerned, and may I also indicate, insofar as our juniors are concerned, that's now me with Advocate Mutlamunyane, I fully take the blame that we gave them. I thought that we were going to have these witnesses, and I kind of gave them assurance, taking from the relations and the communication with these witnesses, that really you may consult, but take your time, prepare yourself, but these are the two witnesses that you're going to call, and they may take over this kind of time. So on that basis, I think I take the blame there. Maybe I should have insisted that they must proceed and consult as quickly or as urgently as possible. And that did not happen, for which I profusely apologize. Perhaps we could have done better. But where we are now, we have now this situation where we don't have a witness who can testify immediately. And one must keep in mind that there is also some form of agreement between the parties to share witnesses' statement. In other words, whoever needs to be called next, we need to present a statement in advance for that. So that's another aspect, Madam Chair, that should be taken into account. That in our request for a week is that there will need to be a statement prepared and given to the other team. And I also must mention that while we know that the issue about the evidence of Advocate Batoi started on the 15th of December, and perhaps one could have anticipated that she might not come back, but the developments continued. And if I'm correct, the last development when the minister said finally decided on the appeal was on the 8th of January, if I am correct, which really then started putting more pressure on. Now it looks like the issue of her acquiring that legal counsel that she had asked for is coming to fore. It looks like it's not going to happen, and that might create problems for this inquiry. I just wanted to bring that in, that's one element that must be taken into account, that there is a date of 15 December, which we acknowledge and we accept, but there are quite a few developments that took place that need to be taken into account.
You are stating that what would have caused problems for this inquiry?
No, I was mentioning only that we know that on the 15th, after the 15th of December, there was then an application by Advocate Batoi, although we haven't seen that application, for the appointment of a team, a legal team.
A request. It was a request to the
well, yeah, I said an application, a request,
the state attorney,
yes,
and to the minister.
Later
there was no
to
application
the
before us.
Yes. All I was indicating is that that issue and the final outcome of that came after the minister had decided. That is now on the 8th of January 2026. And of course followed by what we have now found about the possible conflict of interest as well. I'm just mentioning that those are factors that one should take into account.
So, according to what you've submitted, you interviewed 2 witnesses and they collapsed. We have communication from Major General Boysen, and he says he'll only be available towards the end of February. And then the remaining witnesses have not been consulted.
That's
Now,
that's the essence, yes.
you are here now asking for a stand down, a pause, a postponement. But one can't avoid wondering that what happens after the week that you would have requested, say that request is granted. Would you have witnesses then, or we are going to sit again the whole day having a conversation with the inquiry being put on pause? Because as it is now, you do not have a witness statement that is almost ready. And from your correspondence that we've seen, you were supposed to have exchanged witness statements by the 19th. When was the 19th? Last week, Monday. And it didn't happen. And we are here, today is the 26th. You want us to come back next week, which is February. I'm not sure what is the date next week, Monday. But will we still be in the same position, or the position would have changed? Let us not put Advocate Batohi into the equation, because her issue is a different issue. I'm talking about the evidence leading team and the evidence that they are supposed to lead here through witnesses.
Well, maybe to start with the date of 19 January, that date was not a date on which the parties agree. And I'm not saying it was unreasonable for the Advocate Chauke's team to suggest that date. But we could not agree for the exchange of witness statement. We don't agree, particularly because of the difficulties that we're experiencing with our witnesses. We could not agree to that date. As far as the second question about whether by Monday we would be ready, I have discussed that with my team, and I was given an assurance. Of course, one takes into account that you know, if an individual or a witness says, I can't consult, or I'm not available on this particular date, might create difficulties, but that we will be able to have a witness by Monday to continue in the event that there's still issues about the evidence of Advocate Batohi. Would be able to have a witness to continue with this inquiry on Monday.
Advocate Skosana, maybe let me ask Advocate Mohlamunyane, because you correctly point that when you came, the train was already moving, he was at the helm as the chief evidence leader. I take it, Advocate Mhlamunyani, if you are able to listen as you are moving about. Have you been listening?
I've been listening.
Okay, thank you. Now, I take it that you work as a team, irrespective of who arrived when, but otherwise, as the team was growing, you continued to work as a team. Is that a correct assumption?
It is, Madam Ramagaga. It is correct.
Right, thank you. Now, maybe let us first talk about the witnesses or the persons that you have identified as witnesses to this inquiry. Am I correct when I say that the caliber of persons that you have identified as witnesses and appear on your list of witnesses, they are not lay persons. They are persons who can be assumed to be having reasonable knowledge of what is expected of them. Will that be correct? Generally speaking,
Generally speaking, Madam Ramagaga, that is correct, save for 2 of them. But generally speaking.
Qualifying it was generally, right, thank you. Now, because the main crop seems to be the understanding crop, moving forward, questions that I'll ask will be taking that into consideration. Now, the caliber of those persons is such that they do qualify to assist in developing the draft statements that you would then work on and maybe improve on them in due course. Is that correct?
That is correct, Madam Ramagaga, and perhaps I should indicate to you at this stage, with your permission, what I encountered with my witness, and I'm going to be very direct.
Would you prefer to deal with that first, or should I finish and then you can?
You may finish, Madam Ramagaga.
Right, thank you.
I'll deal with that later.
Yes. Thus far, we are in agreement that they could and they have the capacity to develop the draft statements, which you could then work on and improve on.
Yes, generally.
Thank you. And before you put the names of those persons in the list of witnesses, did you speak to them? And when I say did you, I'm talking about you as a collective, understanding that you are at the helm and you engage and set rules on how to do things. Did you engage? The answer, if it's unison, it will be yes or no. But if each has his or her own answer, you'll answer on behalf of each, indicating that this one has experienced this, or this one has not contacted them at all, or so forth. What is the state of affairs?
Let me indicate to the panel, Madam Ramagaga, that I was being assisted by Advocate Hali SC in identifying the witnesses. And before I was joined by the team, as you see it, I already had certain witnesses, potential witnesses, who we will need as evidence leaders to come and testify and assist this inquiry. After doing so, I then prepared a list. And I must point out at this stage that I prepared that list without consulting those witnesses, without inquiring from them as to whether they will be prepared to testify or not. I was just working on the basis that they are potential witnesses. And in the event that a witness refuses to come and testify, because we do not have, as an inquiry, subpoena powers. We will then inform the panel and our opponents and the Chauke team that such and such a witness who we have identified has reneged on, or has decided not to testify. Now, after having done that, after being joined by the rest of the team, the evidence leaders team, we were then allocated specific witnesses, and I was allocated at General Johan Boysen. I must mention at this stage that General Johan Boysen, as far back as November, December, had prepared draft statements for us. After consulting, after interviewing him and talking to him in Cape Town on or about the 6th of November, if my memory serves me well, 6 November 2025. And indeed, he promised to send draft statements. Indeed, he did so until he gave us a final one. Now, some time ago, a few days ago, maybe 2 weeks ago, I started working on the last draft. And I called him last week and to say to him, General, I'm working on your statement, the last one that you sent to us. He sent the statement to me and Advocate Hali SC. I said to him, I'm working on that statement. I'm trying to finalize and settle it. And I am of the view that you and I should sit in Cape Town. I'll fly down to Cape Town on 2 consecutive days to finalize your statement. We are agreeable about that. I extended an olive hand to him and said, your lawyer or your advocate can be present if she wishes or if they wish. I don't have a problem with that. And he offered to give me, rather, let me correct myself. He asked me as to whether he can give my mobile number to his advocate. I said, yes, you can do that. And then we got into a conversation with his advocate. And his advocate indicated to me that they are working on his statement. Yes, they are working on this statement. I said, I've already started working on that statement. She said, no, we are working on that statement because our client's rights have been trampled on and no one has protected our clients, and our client has to be protected. After speaking to her, I then reverted to General Boysen to say, General Boysen, I'm in this situation. Your advocate is saying 1, 2, 3 to me. Now, I want to find out from you as to whether you would still come to the inquiry to testify. He emphatically indicated to me that he is prepared to testify. He doesn't want to be seen to be a recalcitrant witness. But he has concerns. His concerns are the Danikas issue. The Danikas clips that were flighted on air, and everybody else in South Africa has seen that, and it paints a very bad picture on him, and he wants to deal with that in his fully, decisively, in his affidavit. And he's saying to me that in the course of doing that, he has documentation, some of which is not currently in his possession, is lying around elsewhere, and he still has to get it.
Trying to just indicate that, remember that now I'm not looking for full information.
Yes.
At least you are giving the panel an idea about General Boysen in particular. But main gravamen of my questions is to check about whether, capacity to develop what draft statements, and you have illustrated in your address that yes, they are some of them, of course, and General Poison is one of those that have participated in the evolution of the draft statement thus far. That is correct.
That is correct, but
Yes.
with the assistance,
With the assistance of the
His
legal
legal team.
representative, which is fine.
Yes.
Yes. Now, is he the only person that you have consulted with, or from whom you have sought a draft statement, or what is the position?
so far, yes, Madam Ramagaga. That is the only witness that I consulted with, that I contacted, apart from initially contacting Advocate Molochwa, when I was still alone here. Before I was joined by my fellow colleagues.
Okay, yes,
Yes.
we'll come back to that if necessary. I'm still on the issue of just general questions. Now, the witnesses that you have identified, or persons that you have identified as witnesses to this inquiry, was that list drawn from the names that appear in Advocate Batohi's affidavit or evidence, or are they also constituted of any persons who could have made representations out of interest? What is the position? Is it exclusively from the affidavit, or is it a mix of things? And if it is, please indicate. Thanks.
It is a mix of things, and I'm not able to say which ones have did Advocate Batohi mention in her affidavit. But the majority of the witnesses who are on this list was through the help of Advocate Hali SC, who helped me to identify a witness by telling me that this one is relevant. Look at document XYZ or documents XYZ about this witness is relevant on this aspect. And some of the witnesses I identified myself. But in the main, I was assisted by Advocate Hali SC.
Okay, that's fine. At the beginning, when I started asking you questions, you wanted to talk about whether it's a particular witness or witnesses, remember? Have you addressed that in your answer, especially that long answer, or do you still want to talk about what happened? Yeah.
Not quite. I think I've addressed the issue of Advocate Johan Boysen. I'm sorry, not Advocate Johan Boysen, General Johan Boysen, adequately. He says to me, if I, without being seen to be repetitive, he's prepared to testify, but he can only do so at beyond February, because even his lawyer, his advocate, is indicating to me that that statement will only be available at the end of February.
Okay, thank you. But then you also mentioned right towards the end, you mentioned Advocate Molochwa.
Yes, Madam Ramagaga, I did mention Advocate Molochwa.
Yeah. Is there anything that you want to say
About
her availability and draft statements or so?
Let me indicate this at the outset. This inquiry started on the 17th. We started on the 17th of November 2025. And if I'm not wrong, Advocate Batohi started leading her evidence on the Wednesday of that week. On the Saturday, I picked up a phone and spoke to Advocate Molochwa with a view to find out about his availability for a consultation. The Saturday, the 22nd November. Advocate Molochwa was more than willing to testify. What he indicated to me as his problem was that he no longer has in his possession his statements. And he asked me to send him his statements that he made when he testified in the Nkabinde Enquiry and the Zondo Commission. And I made them available to him. He even sent me clips when he was testifying. And I conveyed that to my co-evidence leaders when they joined me. I also indicated that to Advocate Hali. And today, the situation is different.
What is the state? What is the state of affairs? What has changed?
What has changed is what Advocate Themba Skosana has indicated to the panel, that Advocate Molochwa is now giving several reasons about his unavailability during the course of this year. One of his reasons why he will not have time, if I may use that pun, to come over to testify to in this inquiry is that, one, he's preparing for the 7th, I think, I'm speaking under correction, 7th Comrades Marathon. 2, he has registered a master's degree with one university, I believe it must be one of the universities in KZN. Another reason is he is saddled with matters, his own personal matters that he deals with as a practitioner. He's now in private practice. He's a member of the Pietermaritzburg Bar in KZN. And that he will be having matters, his hands will be full, so to put it, and he will not be able to assist.
Okay, thank you. So thus far, is the witness, is General Boysen the only witness that you can tell us is available for the Katomeina issues? Or is there another one that you can say, as far as I'm aware, this witness or these witnesses are still committed to the cause?
One of the witnesses that I believe is still committed to the cause is Advocate S. Riley. And she has been allocated to Advocate Mutsweni. And I've given Advocate Mutsweni her mobile number, which I asked from the NPA team. And as soon as I believe we leave this chamber, he'll get in contact with her. The next one is the one allocated to me, General Ntlanhla Mkhwanazi, whose evidence, according to what we have, will not be long. And I said to myself, well, this one will not be long. I'll see him later after I shall have dealt with the General Johan Boysen's issue. So I packed it, maybe at my own peril, or at the peril of the panel, rather the evidence leaders. I just packed it because I wanted to first deal with, because I thought he will not be a complicated witness. But maybe upon hindsight, because I should not have acted in the manner in which I acted. I should have consulted him. Upon hindsight, I realized that.
No, thank you very much, Advocate Mohlamunyane.
Thank you, Madam Ramagaga.
I'm making just a general statement to the evidence leading team. You were appointed by the President to execute your function. And if the witnesses or potential witnesses who are officials in the NPA makes it difficult for you to execute your function, shouldn't you place that in writing and address that to the minister? That we've been given this task, we are not able to perform our function because of this, that, and that, and that, especially the witnesses who are officials or advocates in the NPA.
May I answer, Madam Chair?
Yes, I just want to know.
Yes. You're correct, Madam Chair. That would be ideal. That would be a proper position to take to inform the minister about the hindrances that we encounter. But in this matter, about these two witnesses that Advocate Skosana SC has referred to, one is Advocate Simpiwe Cyril Molocho, who's no longer in the public service. He's in private practice now. I'm not sure whether we can report him to the minister. The second one is Advocate Muiponi Nogu. She's also the former DPP of KZN. In 2012, thereabout, she was appointed the DPP. And as indicated already by Advocate Skosana SC, she was willing to testify, but she has changed colors now. I wonder whether it will be appropriate to report them to the minister. They are no longer in the public service, Madam Chair. Thank you.
Nogu?
Yeah, Advocate Nogu is no longer in the public service. She has resigned.
And Advocate Mlochwa? Advocate
Mlochwa is in private practice now. He's in private practice as a member of the Peter Marisbeck Bar.
I'm not thinking in terms of reporting as such, but just placing information before the minister. Because at a critical time, these advocates served under the auspices of the department. Not necessarily that they be investigated, but just to place information for the minister to understand the challenges you are confronted with as evidence leaders.
I agree. I'm inclined to agree with you, Madam Chair.
I may be wrong, but it's a matter that on your own you can consider.
We will indeed consider that. Thank you, Madam Chair.
Maybe just to add, although they are in private practice, but they are within a regulated space.
Yes, of course, Madam Baloyi.
So you can deal with them within that regulated space.
Especially that they are members of the LPC, Legal Practice Council. I'm not sure about Noko, but she's still an advocate. She's still holding the title of advocate.
As long as she still holds, yes. And she is a member of, yes. Any legal practitioner in South Africa is regulated by the LPC.
Indeed.
So you can deal with them within that space.
We will do that. We'll consider that. Thank you, Madam Baloyi.
That said, what is your final proposal, Advocate Skosana? I know that you have intimated that Advocate Hali might want to say something, yes. But from your side, what is the final proposal you wish to make to us for consideration?
Madam Chair, our proposal is that we request the postponement or adjournment of these proceedings until Monday, and on the basis that on Monday we should, and perhaps Advocate Hali will touch on that if he's given an opportunity. On Monday, we will have some headway insofar as the issue of the evidence of Advocate Batoyi is concerned, number one. Number two, if not, if Advocate Batoyi is unable to continue with the testimony by Monday, we will make sure that we have a witness to continue giving evidence before this inquiry.
I'm making an undertaking that if Advocate Batoyi's issue is not resolved or she's not able to take a witness stand, you as evidence leaders will be ready to proceed.
Yes, indeed, we are making that undertaking.
Supposedly, you would have exchanged the witness statement in advance with the Advocate Chauke's team?
Yes, Madam Chair, we would at least there would be witnesses' statements. Maybe not all the statements, but there should be a statement of a witness. The witness we would have prepared for Monday will have the statement of that witness. Also
The
shared.
question is whether you would have exchanged the statement that is available with the Advocate Chauke's team in advance, probably on,
Yes.
on Friday. If we are to proceed on Monday with that particular witness, I'm trying to make sure that you are making this undertaking seriously, understanding that the other side must have had a side of the statement.
Indeed, Madam Chair, the undertaking is to also share that a statement of that witness in advance before Monday.
Thank you, Advocate Skosana. Thank you, Counsel, all of you. Advocate Goitobi.
Madam Chair, I suppose there's very little for me to say at this point, other than to ask who.
Do you know Advocate Skosana, or do you have an idea, more or less?
Chair.
In which event the team for Advocate Chauke will assess its position and decide what they want to do? Advocate Riley, they say.
Thank you, Madam Chair. I suppose it also comes with the
Say something. You may come forward, Counsel. I know that there is another, you can shift a bit. Yes, thank you.
Thank you, Madam Chair. There is no burning desire on my part to say anything per se, other than to explain what our position is. So, what we had requested from the panel, pursuant to a letter which was addressed to you, Madam Chair, as the chairperson of the panel, was a request to allow us to consult with Advocate Batoyi while she was under cross-examination in order to advise her. The context to that, much of which has already been canvassed, was that we were initially briefed to act on behalf of the NPA. Those instructions were given to us by the state attorney, and I imagine that it came from the exco of the NPA, which would have included, amongst others, Advocate Batoyi. When Advocate Batoyi, on the 15th of December, stood down in order to seek legal counsel, her desire was to seek the advice of counsel other than myself and Advocate Lekgetho. We, myself and Advocate Lekgetho, had initially been briefed, as I said, on behalf of the NPA. You may well recall from previous exchanges that we had that I was at pains to point out that we were acting for the NPA and we were not part of the evidence leaders team. At any rate, all of that culminated ultimately in the request by Advocate Batoyi to the state attorney to have the counsel that she wished to have appointed to assist her in giving advice pursuant to the indication that she had given to the panel on the 15th of December. That request, as I understand it, ultimately percolated up to the level of the Solicitor General, who declined to make the appointments. Reasons were given, And the Solicitor General concluded by stating that she had the right of appeal and she should appeal to the Minister. The Minister was then, after, as I understand it, after some further correspondence was exchanged with the Solicitor General, the Solicitor General indicated that he stood by the decision that had been taken. What then transpired was that Advocate Batohi then appealed to the Minister, and the Minister's response was that there should be a consultation, that she should rather seek the advice of myself, of me, and Advocate Legeto. After considering the correspondence, we decided to write to the panel, as I've indicated, to make the request to the panel that we should be allowed to consult with her, because it was anticipated that we would need to consult on matters that may well involve issues that were canvassed during the course of of cross-examination. Now, subsequent to that, and nearing the present date, it became, I certainly had occasion to reflect upon this, and how would I be able to consult with her, and how would I be able to properly address some of the issues that were reflected in the request to the State Attorney. It seemed to me that it was inevitable that a conflict of interest was going to arise on the one end between Advocate Batohi and the various options that may confront her and the NPA. Bearing in mind that my brief came to me to represent the NPA and not to represent Advocate Batohi, and that her request had been made initially for other counsel to represent her. Now, it was in that context that we approached the panel this morning and indicated that we believe that we are heading inevitably towards a conflict of interest. We would not be able to properly discharge our mandate to either one of those clients to be able to canvass every aspect that was in the best interest of either one of those two clients. Now, at the moment, we are unable to take instructions from our client, which is the NPA. Until now, our client has been represented by Advocate Batohi, as well as the EXCO. So where necessary, I've had to take instructions from the EXCO. But since the latter part of last year and the early part of this year, that EXCO has been somewhat denuded of some of its members. Some of the members have fallen away. They've either resigned or retired. I stand corrected. I don't know which. And at least two of them are simply acting members. So the upshot of it all is simply that they are unable to provide me with instructions, even if they were desirous to do so. It's possibly in the context of that, having explained it to the evidence leaders, it's possibly in the context of that the suggestion was made that we should stand down until Monday, because Monday is the date on which the new National Director of Public Prosecutions takes office. But I don't anticipate, unlike, and I don't wish to comment necessarily on the stance adopted by the evidence leaders, but I certainly don't have the confidence necessarily because I simply haven't spoken with the new National Director of Public Prosecutions, whether he would even entertain my presence on Monday. So that's something that still has to happen. So I can't give any undertaking as to when that would happen. My experience, having worked with different organs of state and different departments, my experience has always been that I'm going to be requested to provide some kind of a memorandum in order to bring the individual who's going to have to take the decision up to speed. I anticipate that that would happen with the new National Director of Public Prosecutions. To put together, and of course at this stage I simply haven't been asked to put together anything, not a memorandum or otherwise. So I'm still hoping to get an audience with the new National Director of Public Prosecutions. I might be, I'd like to think that I would be a priority for him, bearing in mind the circumstances of this matter. But I'm simply, as I haven't spoken with him and I'm not in a position to comment either way. So that's the position where we find ourselves in, and my position applies equally to my junior Advocate Lafeto. There was a question that was posed, if I recall correctly, by Advocate Baloyi Mary as to whether, when the minister had been approached, had she been approached about the potential conflict of interest? The short answer to that is no. But let me, there were certain aspects of the minister's letter that I thought may require me to revert to her, if I was permitted to do so. The one concern that we had when we considered whether we ought to go back to the minister was we had no understanding of the regulatory framework that gave rise to the minister's position as the appeal body. So we read through all the legislation, the State Attorney Act, we read through the regulations, and we read through the through the policy that we had been referred to. We were unable to find any particular document or instrument that could talk to the question of whether the minister was functus officio, as it were. So we did consider the possibility of going back to the minister, not specifically on the question that was raised, but on certain other aspects of the letter. But that's as far as we could take it. That's where we stand at this point in time.
Now, given the fact that a decision has been taken already by the minister, assuming she had no power to decide on the matter, if she's functus officio, but a decision has been taken, will there be any harm in you and your junior or even the NPA presenting this difficulty to the minister that you anticipate? Because as I understand the correspondence, the minister decided on the basis that you and the junior are here and you could represent Advocate Batoyi at the personal level. That's how I understood.
That is correct, Madam Chair.
Yes, the correspondence. But if the minister is to be advised that the converse is true, you are actually not in a position to represent her because of this potential conflict, a matter which was most probably, as I understand now, not brought to her attention that might just resolve this whole conundrum. And the minister may revisit whether she is functus or not. She may just maybe reflect, or the Solicitor General himself may even reconsider the position and decide otherwise.
Madam Chair, it can't do any harm to revert to either one of them. It would seem to me that given the level to which it has advanced, the appropriate person, if we are to go back, the appropriate person to go back to would be the minister now that she is seized with the matter. As I said, this issue arose, the question of the conflict of interest arose fairly recently. So up until last week, it wasn't always apparent to us that there would have been a conflict of interest. It was upon reflection that we came to appreciate that there would be a conflict of interest.
Yes, and if I may guide.
But I take your point, if I may conclude, I take your point.
Yes,
and certainly during the course of the debate between the panel and the evidence leaders team, it struck me as being a rather sensible approach to adopt.
Council, if I may guide, if you may consider that approach, that the new NDPP has not taken office as yet. As we speak, Advocate Batoyi is still the NDPP. And also given the fact that these are polycentric issues that will entail a decision made or to be made by a member of the executive. You know, when you talk money in government, especially because the NDP or NPA falls within the auspices of the department, of the ministry. Am I right?
So
I'm not sure whether I'm putting it correct, but it is an institution in respect of which the NDPP works hand in hand with the Minister of Justice.
That is so, my lady. If I understand correctly, functional responsibility ends at the National Director of Public Prosecutions, or operational responsibility. But insofar as the responsibility for finances are concerned, that responsibility ends with the Department of Justice.
Yes. The issues that we are dealing with now concerns finance, budgetary matters, and the minister seems to be the right person to go to insofar as Advocate Batoyi's request is concerned. So if it is discovered, as you'll be talking to one another, that there is a conflict of interest, a matter that might not have been brought to the table of the minister, or even the Secretary General, Solicitor General.
The Solicitor General.
The Solicitor General may reconsider, the minister may also reconsider, and we may not even be here now. We should have made a headway. So it seems to me that on the challenges that you and your junior are confronted with, which is quite understandable, perhaps now that the minister has decided that you must represent her or consult with her, and you are now confronted with all these sorts of legal challenges, because even if you were to be appointed to represent her, the question that then arises is whether you have a right to consult with her on matters that arise during consultation, cross-examination. That opens all other difficult challenges, as you know. So it seems to me that the buck stops with the minister. And if she is to appreciate these challenges that you are placing before us, she may just as well decide otherwise. a week. I'm not sure. But it seems to me that the first person to communicate with is the minister, because the new NDPP has not assumed office. Advocate Batoyi, you cannot talk to her. She's the NDPP, but because of these issues that you are grappling with, you cannot talk to her. And the minister is the last place to go to if the Solicitor General does not give you out and he thinks that you are not entitled. I'm sure you'll start there, and then the matter will then go to the minister. He's here, you can discuss the matter without necessarily having to write letters to each other. And I'm sure the Solicitor General appreciate the very challenges that you are presenting to us. No, thank you. I'm not sure whether my sisters would like to ask you any question.
I have just one. I'm sorry, I thought I would keep quiet because it's late in the day, but I can't help myself. You painted a picture that it seems like literally EXCO within the NPA does not exist anymore. You said some have left and some are acting. Two
of them are acting, that is correct.
Acting. And how many have left?
If I understand correctly, one is left, and Advocate Batoyi is the other one.
Yeah. How many?
I
how many
think
members?
I think there may be one vacancy. I think there were supposed to be 4. I stand corrected. 4 deputy national directors of public prosecution, all of whom would be ex officio members of the executive. 2 of those are acting. 1 is left. And I think there might be a vacancy. I can take instructions.
And then there's Advocate
And then there's
Batoyi.
Advocate
So it
Batoyi.
means you only have 1% or 2. So they
We
can
only
never
have 2
correct.
acting appointments.
Yes, they can never correct.
They can't correct, and even if they were correct, I would be very surprised if they would take a decision of this nature.
If they would take a decision. So what you are literally saying to us is that you are now sitting here without anyone giving you instructions. You are sitting here. You since received your instructions right at the onset, and as we go along, you don't have.
Well, sometimes when the head has been chopped off, the body continues to operate even despite the head being absent. But in this case, that's not the case, because management, you still have a manco, you still have the rest. I mean, the operations continue despite the problems that may confront the EXCO. Thank you, Madam Beloit, Mary.
Yes, wait. Advocate Haile, on the issue of the EXCO, I'd like to establish maybe what circumstances or the process leading to your appointment to represent the NPA. Now, or the recommendation for the state attorney to appoint. I get there's a process. So what I'd like to establish is whether the decision to recommend that you be appointed to represent the NPA, did it come from EXCO, or did it come from Advocate Batoyi as the head of the institution, or what is the position? Because that information will assist us to weigh on what you have just informed us of, that the EXCO, the NPA EXCO, seems to be dysfunctional or paralyzed because of other reasons outside their control. If he doesn't correct, we understand. If he doesn't correct, it would not make decisions or whatever. Whatever the case is, that is actually paralyzing that body in particular.
Thank you, Madam Ramachaki. I mustn't be seen to be saying that the EXCO is dysfunctional or that it's impotent at the moment. I'm not saying that at all. I think it's specifically in relation to this issue. I would imagine that in relation to other issues, Advocate Patoy would be quite competent to continue to take the helm. It's specifically in relation to this matter. But in relation to the question that you posed to me about how I was briefed, quite frankly, Madam Ramachaki, I actually don't know. All I know is that I get a brief from the state attorney, and in the context of this, it would of course be preceded by a telephone call. Am I available for this? Because I have been involved in the matter previously, as you would be aware. But it's in that context that I get that I would have been briefed and asked to respond to a request to participate.
So it will be fair to say you will not know as to whether it becomes necessary or it is actually necessary for MENCO to sit and agree about a recommendation for the appointment or not.
Are we talking about MENCO or EXCO?
EXCO, I beg your pardon. Is it EXCO, MENCO?
So
Let
EXCO
me
is...
just place it on record because I may have used it interchangeably, that whenever the record reflects EXCO or MENCO,
Yes.
I'm using the term interchangeably.
Very well.
Thank you.
Yes, okay. So we're talking about EXCO. My understanding is that that decision is one that has to be taken by EXCO.
Okay.
That's my understanding.
Right. Okay then. Thank you.
Thank you, Madam
Thanks.
Ramachaki.
And which decision is this, by the way?
Pardon?
Which decision is this, by the way?
To eliminate the possibility of a conflict of interest, so that if the whatever decision is taken ultimately by Advocate Patoy, to allow that the NPA accepts that the fortunes of the two are inextricably tied and that they would go with whatever decision, so I can advise both of them. And the advice I give to Advocate Patoy would be the advice that the NPA would accept. You made the point early on, Madam Chairperson, about approaching the Minister / the Solicitor General of the various options that that confront me, or the various options that suggest themselves to me. It would strike me that that's the most simple of the two options, which is to approach the Solicitor General or the Minister. It's something that could resolve the issue much quicker than the other one.
Councillor, that seems to be the better approach given the circumstances. But you'll weigh your options and you'll indicate finally to the Minister what your challenges are. And I'm sure the evidence leading team will do the same.
As it pleases you, Madam.
Yes, thank you. Thank you very much for apprising us of all this information, and hopefully you will be in a position to execute your mandate, your initial mandate, and proceed to assist as you have been doing. And if a potential conflict is or arises or has been found, the team will take appropriate steps. What those steps will be, we have engaged with all of you, and you'll decide how to approach the matter.
Thank you, Madam Chair.
We need a few minutes to confer with one another regarding the requests that you've placed on the table. We will reconvene in 10 minutes. 15 minutes? At about 20 to 6, we will reconvene, give a direction.
Thank you, Madam Chair. Whilst I've got the mic, and it's been a long time since I've had the mic, I may as well make the most of it. What Advocate Patoy has communicated to me just before she departed was that she was going to have some difficulty coming back this week. She's got meetings with various people, including the President, in the forthcoming days. So she's asked if she can be excused. It seems like it would be inevitable that she will be excused anyway, but that she not be required to return whenever we get to, whether it be on Tuesday or whether it be on Friday. But whatever decision is taken, if she can be excused, and then I can communicate that to her through one of her assistants who's here tonight.
Advocate Halley, it doesn't appear to us that there's anything that can really be done given the circumstances. Even if she were to attend, she wouldn't be testifying, pending the determination of the very issue that
Indeed.
has given rise to all these debates and exchange throughout the day. Yes, she is excused. I'm sure by Monday she will be here.
Thank you, Madam Chair.
Yes, thank you. We will adjourn until 20 to 6. Just give us 15 to 20 minutes to decide, and we will come back. We'll adjourn. Thank you. Good afternoon, everyone. Our apology for taking a little longer. There were some few other matters that we needed to consider, given the request for a postponement to next week, Monday. We have drafted a very brief ruling, which read as follows. The evidence leading team applied from the bar for a postponement of the inquiry for a period of a week, that is until Monday, the 2nd February 2026. The request is made because of two issues that have arisen. The first, concerning a potential conflict of interest between the NPA legal team, namely Advocate Hali SC and Advocate Lekgeto, and their proposed role to represent Advocate Batoyi. Advocate Batoyi had unsuccessfully requested the Solicitor General to appoint a further legal team to represent her. She was advised of her rights following the refusal by the Solicitor General to appeal to the Minister of Justice and Constitutional Development. Advocate Batoyi did appeal the decision of the Solicitor General. On or about the 8th of January 2026, the Minister advised Advocate Batoyi to use the services of Advocate Hali SC and his junior, Advocate Lekgeto, who, as I have mentioned, have been instructed to represent the NPA. On or about the 9th of January 2026, Advocate Hali addressed a letter to the panel requesting to consult with Advocate Batoyi following the decision first by the Solicitor General and subsequently by the Minister as mentioned in the letter. The consultation was to cover aspects that Advocate Batoyi was testifying on whilst under cross-examination. Advocate Chauke's legal team wrote signifying their intention to oppose the request to consult with Advocate Batoyi whilst under cross-examination. The evidence leading team seeks to confer with the State Attorney with a view to establish whether such potential conflict of interest exists, and if so, what appropriate steps they should take. During engagement with the evidence leading team, in considering the request for a postponement, it emerged that neither the Solicitor General nor the Minister had been apprised of such potential conflict of interest. Therefore, the team requested time to consult and make an assessment whether such conflict exists. The second issue giving rise to the request for a postponement concerns challenges with potential witnesses, especially in relation to the Kato Mena matter. Seemingly, some of the witnesses who had been identified and had been consulted with have now withdrawn their availability. Other witnesses, including those with regard to the Mdluli matter, are yet to be consulted by the evidence leading team. The request for a postponement made from the bar necessitated varied questions from the panel because a postponement is not there for the taking. There can be no doubt that the request for a postponement for a further week will cause a further delay in finalizing this matter, or rather with making progress in relation to this matter. Thus far, only one witness, Advocate Batoyi, has testified and is still under cross-examination. Having considered the request and the submissions made by the legal teams, we agree that a postponement is, under the circumstances, warranted. However, the request until Monday, the 2nd of February 2026 cannot be granted because such a postponement to that date will go beyond the period allocated by the President for the inquiry. It must be mentioned that the request for extension of the period allocated has been made to the President, and the panel still awaits the decision from the President in that regard. It must also be mentioned that the evidence leading team has made an undertaking to provide the witness statements to Advocate Chauke's legal team by Friday, the 30th of January 2026. The further undertaking was that the inquiry will proceed without further interruptions. Accordingly, the matter is postponed to Thursday, the 29th of January 2026. And we request all the parties to be here on Thursday, the 29th of January 2026. We so order.
As you please.
As it pleases.
We will adjourn until Thursday, the 29th of January this year.